Court officer? Madam, sir, court officer. ಕೇಳಿಸ್ತಾ ಇದೆಯಾ ಸರ್? ಕೋರ್ಟ್ ಆಫೀಸರ್ ಮೇಡಮ್ ಫೈನಲ್ ಹಿಯರಿಂಗ್ ತಗೋತಾರಾ?
ಈ ಪ್ರಶ್ನೆಗೆ ಉತ್ತರ ಇಲ್ಲ ಮೇಡಮ್ ನಮ್ಮ ಹತ್ರ.
ಕೇಳ್ತೀವಿ ಮೇಡಮ್ ಅಷ್ಟೇನೆ, ಗೊತ್ತಿದ್ರೆ
ಹಂಗಲ್ಲ. ಈಗ how can I tell whether it will be taken or not?
Just asking if you have knowledge.
ಈಗ ಏನ್ ಗೊತ್ತಾ, ಈ ಕ್ವಶನ್ಸ್ ಗೆಲ್ಲ ಆನ್ಸರ್ ಹೇಳಕ್ ಆಗಲ್ಲ ನಾವು. ಅಲ್ಲ, ನಾನೇನೋ ಹೇಳೋದು ನೀವೇನೋ ತಗೊಳ್ಳೋದು ಕನ್ಸೆಪ್ಷನ್ ಆಗ್ಬಾರ್ದು ಅಷ್ಟೇ. ಡಿಸ್ಪ್ಲೇ ನೋಡ್ಕೊಳ್ಳಿ, ನಾವು ಡಿಸ್ಪ್ಲೇ ಕೊಡ್ತೀವಿ. ಓಕೆ ಓಕೆ.
Kindly, one maintenance matter, mother has been granted 5,000. That has been challenged by the daughter, ma'am. B group matter.
Take it. All those matters which are of, not fresh matters. Looking into the thing, add it.
Much.
Yes. MFA Quarter 23 matter, Millet. Grievous injury urgency in hearing the matter. Urgency.
Yes.
No. MF death matter, my lord. We file a hearing IF for releasing of amount, my lord.
Kindly 23 matter for admission.
21, my lord.
Releasing of amount.
2021, my lordship. Admission.
Matter is urgent because the wife has been told not to move out of the Bangalore itself, which is unfair, my lord. Even if she goes to Mysore, there is a problem. She can't even take the kids. This is a matter where your lordship had dealt. In this order, the wife is restrained from taking the kids anywhere, even for a short.
It's coming up. It has never come up.
It has come up earlier, my lords. Not now. It had come up a few months back.
That time order was like not to leave the.
The trial court made an order not to remove the kids from the jurisdiction of Bangalore. We have no intentions of settling elsewhere. She is here permanently resident. These are the two kids which your lordship has dealt with in another matter. Now this, my lords, recently she took the kids to, I think, close by to Dodbalapur, that is near Nandi Hills. There was an email saying that it is a contempt. Even outskirts also she cannot take the kids, even to a small resort. Then there is a mail and a contempt notice issued by the respondent.
Monday, Tuesday. Yes.
My lord, 2023 matter.
Give all the memos
Please,
to the court officers.
It's a 2022 matter. And for there has been stay on the proceedings since last 3 years. If a date can be given somewhere in next week, my lords. Next Tuesday or Wednesday, if your lordship can accommodate.
I am the petitioner appearing party in person. My case is posted on 16 September for admission. I request Honorable Court if it can be addressed early, because I have submitted all the evidences regarding the case, and there are.
Where is the writ petition? Which year is the writ petition?
2025. This year.
2025 matter. We'll hear it. No urgency before September 17th. Yes. All the rest.
Page wise adjournment. Page number 2, serial number 6, 7. Page number 3, serial number 8 to 12. Page number 4, serial number 13 to 18, page 5, 19 to 28.
My lord, serial number 27. I appear for the petitioner, my lord. The settlement agreement has just been finalized. It may be had any date next week. The other side is present.
Last time, both of you only requested for this.
Yes,
for
my lords.
today.
It's just some more terms have to just be finalized, my lords. It should.
Do it every time the matter will not come and again court will not adjourn
My
it.
lords, any date next week, we'll have it ready, my lords.
May I request for third, your ladyship, subject to the convenience of the court?
Yes, list on third. No
Grateful.
further. Yes.
Much obliged.
Page number 6, serial number 28. Page, list number 2, page 1, page 2, page number 2, 3 to 6, page number 3, 7 to 10, page number 4, 11 to 14, page number 5, 15 to 15, 16, page number 6, 17 to 21.
My lordship, serial number 20, please,
20.
yes, marshal. Out of station, my senior.
At the request of learned counsel for the appellant, list this matter on 4th of November.
Thank you, much of it.
Serial number,
Seven.
serial number 21. ma'am. Serial number 21.
Hmm.
My senior has been out for an emergency thing. She wants to post sick.
Inform the other side.
She should have informed, ma'am.
TP.
She said me to.
Because she would have informed
Yeah, ma'am.
at request this also on this on November 6th.
Page number 7, serial number 22 to 26.
My lordship, serial number 23 for appellants, my lordships. I pray for time.
Why?
My senior is held up with another place matter, my lordships. He need to come down.
Whole day.
No, actually, there was a critical matter, parted matters, my lordship.
22 respondents are already served.
Ravi.
If
Yeah.
it is your senior, your
any
senior's presence is not necessary, you come. We will, court will pass the order.
Any short date, my lordships, if possible.
No short date. List the matter on November 18th.
Please, my lord. Please, my lord.
Yes.
Page number 8, serial number 27, list number 3, page 1, serial number 1 and 2, page 2, serial number 3, page 3, serial number 4 to 8, page 4, serial number 9 to 11,
Yes.
list number 4, referring to Lok Adalat.
All the matters are referred to Lok Adalat. Entire list number 3, 4.
I'm a request some, in the list number 4, 23 serial number is dismissed. Our claimant's appeal. It is not possible. Please.
Delete this
Delete.
23, post in the usual course. Yes.
Please.
Any other
Much.
matter?
Much.
Page number 5, provision court matter, serial number 1 and 2.
Serial number 1, my lord, kindly be taken.
For the respondent.
Serial number 1, my lord.
1 minute, 1 minute.
Fifth list, my lord.
How many lists are today? Ah.
First matter, my lord, may kindly be taken up next week, my inform my learned friend.
Yes, next week at request of both the parties.
Serial number 2, serial number 2, pressed for time, 2 weeks time.
Why this you pray for time? Other you say urgent out of turn the matter has to be taken.
File is
Yes,
certificate copy applied.
To also give some on 22nd of September, 24th of September.
Please.
My lord, list number 3 is referred to Adalat, my lord.
List number 4 is referred to Adalat.
Much obliged.
List number 1, parted matter, serial number 1, Sudesh Kumar Acharya for petitioner, Ajit
Lord.
Anand Shetty.
The time is short, my lord, for arriving at a settlement, my lord, looking into the paramount consideration of the doctor who is pursuing her education. Well, after I took time from your lordship here, well, may I pass on the order sheet of the further developments in the matter, my lord. The family court judge, my lord, she has directed the party to be kept present before her to arrive at a settlement on 2 dates, my lord. The date has been given.
Petition, we don't have to look into all this.
Because
Please, the order issued
just for
before
my
that.
persuasion, I am presenting that document.
We'll
That I
hear
did
this
my,
part. We'll hear this matter.
I did my attempt, my lord.
Please,
For- Well, I may proceed, my lord. No, please.
where is the impugned order?
Because of the reason, my lord, the family court judge, my lord, he made attempt for 2 occasions to keep her present before.
Because the main matter is pending there, that can be taken care of. Let's not keep the writ petition pending here
Yes.
against an interlocutor. Yes.
My lord, the one petition filed by the wife, my lord, that is MC 97/2019.
Hmm. Seeking
Seeking dissolution of marriage.
and 76
That is prayer, my lord.
by whom? By husband.
That is a wife has sought for, my lord, the dissolution of the marriage.
No, there are 2 MCs.
Yeah, I filed, my lord, petition in my jurisdiction seeking for restitution of conjugal rights.
Hmm.
That is in MC number.
76.
Yes, well, MC number 359/2019.
No, there are only.
Well, IA for stay, that I have produced the order. Along with the IA 1 for stay, I produced the order along with the IA 1/2002.
Her wife's MC is 97.
Wife's petition is MC 97/2019.
Husband's MC is?
Husband's petition is, my lord, MC number 359/2019
Seeking restitution.
on the file of the family court, my lord, Hubli. On the file of the family court, Hubli, my lord.
Yes.
My lord, my MC petition 359/2019 came to be allowed, my lord. That I have order, I have produced at annexure H, my lord, along with my IA 1/2022. On the basis of which, my lord, I sought for stay of the proceedings before the family court. That is when my petition is pending consideration before the Hubli court. All these proceedings before her MC be stayed is my prayer before in my application, which came to be rejected. Now, on account of my dissolution of the marriage, now there it came to terminated by way of passing the decree for restitution of conjugal rights. Either, my lord, this MC has to go on its own merits, and, my lord, either I have to execute that order along with as per the norms known to law.
Agreed.
And, my lord, your lordship may also, my lord, keep open that liberty, my lord, persuasive for mediation also that keep. And before the family court, that attempt is there, my lord, at least some alert will be there, my lord, for the family.
My lord,
In MC number 359 of
in this they
2009.
have said that they will be coming up for settlement. They said that they will be coming up for settlement, but there is no news at all, my lord.
That's what, it's all goes on, I know. Whenever the matter comes up for hearing, all these things go on. So ultimately, whatever to be settled, settled. Nothing to be decided in this petition. Agreed with orders passed in I number 1. Wherein an application filed under section 151 CPC to stay the further proceedings till pending disposal of MC number 359 of 2019, pending on the file of the family court of Hubli, whereby by order impugned, the court had dismissed the said petition and posted the matter for petitioner's evidence by 23/3/2021. The petitioner husband had filed MC 359 of 2019 on the file of the family court Hubli, seeking restitution of conjugal rights. The wife had filed on the file of which court this is?
In MC number, my lord,
She has filed on the file of the senior civil judge
97,
court, ODP,
97/2019.
MC number 2000, MC number 97 of 2019, seeking divorce. The present application came to be filed, seeking stay of all further proceedings in the divorce case till the restitution cases ordered. That came to be dismissed by order impugned. Then counsel appearing for the petitioner, husband submits that the MC, that is 359 of 2019, is already allowed. Further, it is submitted that already the family court had asked the parties to be present so that an amicable solution, the matter can be amicably settled. He submits that the matter may be adjourned. In the meantime, the parties can settle the matter before the family court, as already appearance of the parties as ordered. Learned counsel appearing for the respondent by submits that, though it is stated that they're ready for a settlement, but they have not come forward. Next paragraph. Having heard the counsels on either side, will submit a non-report. If there is a settlement between the parties, And as the family court has already ordered the appearance of the parties, any order that is passed by this court in this writ petition will not come in the way of the parties in settling the matter. The limited issue before this court is whether the order impugned is justified or not. And further, in the light of the fact that already the reason for filing this application is as a restitution petition was pending. So according to the husband, unless until the restitution petition is decided, the MC seeking for divorce cannot be proceeded with. Now, by virtue of the orders passed in the restitution petition, nothing survives for consideration in this petition. Accordingly, in the light of the dismissal of MC number, allowing MC number 359 of 2019, no further orders request to be passed in this petition. It is open for the parties to go for mediation as per the as ordered by the family court. Yes.
It's open for the approve the
Yes.
mediation.
Yes.
That observation be there, madam.
Yes.
Two, Arun Govindraj for
For
petitioner.
the petitioner, your ladyship, may I kindly request for the matter to be passed over, your ladyship?
Yes, my lord, the matter may be passed over.
Cell number 3. Sri Jaiprakash Rao.
Hearing for the petitioner. Your Lordship, I am filing a memo for withdrawal. I will withdraw this petition.
Why you want to withdraw?
Your Lordship, it is a consented order and we are going through the this one trial court for a modification of that order. So this court doesn't have the jurisdiction to hear on the consented order. So on the impugned order, we are filing application in the family court for the modification.
Agree with the. Where is that order?
Annexure A,
Page number.
page number
16, Your Lordship.
16. 15, 16.
As both the parties have entered into a compromise, basing on that compromise, an order was passed on 17/2/2024. That order is questioned before this court. Now the memo is filed seeking to withdraw the petition. The memo is taken on record and the petition is dismissed as withdrawn.
Your Lordship, may I ask for one direction? They may be allowed to withdraw provided they clear the arrears because of the interim order they were paying only 50.
Yes, next.
Cell number 4. Kumar G.
I am the counsel
appear
for
for
the
respondent
petitioner in
number
this
Y.
There
case.
was an interim order in this. There was an interim order.
Earlier it was interim order was there.
You that?
Interim order was there.
What was interim order?
It was the stay of this maintenance. It was already 50-50, but this court had ordered for the maintenance to the wife of 12,500 and school fees 50%, 50-50 share by wife and husband. Interim order dated, huh? Nine four.
Before that, writ petition is filed on so and so. On 9/4/2025, an interim order is passed wherein this court has observed, the coordinate bench of this court has observed that when counsel for the petitioner contend that by the order dated 17/2/2024, the petitioner had agreed to pay 50% of the education expenses and 50% of the monthly maintenance. Therefore, there shall be a stay of the execution of the order dated 17/2/2024, subject to condition that the petitioner paying rupees 12,500 per month as maintenance to the respondent, and petitioner shall pay 50% of the educational expenses of the minor child directly to the school or to the account of the respondent or to the court. He shall pay the amount as per the order dated 17/2/2024. If there are any arrears if there are any arrears, the same shall be paid within 2 months from today. What happened to this?
We have been paying, paying regularly. That amount has been paying 12,500 to the wife, and education we have been paying.
They have paid 50% only upon reminder. But however, that was due to the interim stay. So now if they want to withdraw, let them
Interim
clear.
and counsel for the petitioner submits that as per the order, they've been paying the, they have complied with the interim order.
Interim order, yeah.
Land counsel for the respondent submits that the petitioner has not complied the consent order that is impugned dated 17/2/2024. The petitioner, the memo is filed seeking to withdraw the petition, and if the amounts are not paid as per the compromise, as per the order dated 17/2/2024, it is for the respondent to execute the order.
Much obliged.
Yes.
So number 4.
My lord, in
I
item
appear for
4,
the petition in this case, my lord.
my lord, in item 4, I appear for the respondent wife, my lord. This matter came upon 21st, my lord. My lords asked me to, my lord, take instructions with respect to 3 aspects. One, my lord, with respect to MTech degree of the wife under earning capacity, and with respect to the alleged earnings which the wife has received from SLN floor mill and the demat account. My lord, we have taken substantial instructions, my lord, requesting for 1 day adjournment, my lord. We'll file few documents which are necessary. May have taken up day after tomorrow. My lord, one instruction is with respect to that SLN floor mill, which my learned friend is stating that wife is earning that amount. That SLN floor mill, my lord, is belonging to the brother of the wife. So, my lord, that whatever the amount, paltry amounts, my lord, 2,000, 3,000, which was paid by the brother, it was a gratuitous amount, my lord, and wife is not a partner or a owner of that SLN floor mill. With respect to the MTech, my lord, I have some instructions that she was a guest faculty. She is not a permanent lecturer.
She's earning.
She was earning, my lord. She was earning around.
Not earning.
My lord, what happened? The instructions are, after her marriage, my lord, at the instance of petitioner, the wife discontinued her job as a guest lecturer, my lord. That we have stated in the affidavit and the statement of objections. Now, my lord, the requirement for being
I think marriage, if I remember on the last occasion you submitted, it's very shortly.
3 months. 3 months.
3 months.
I bowed.
So, when she last worked?
My lord, with respect to that, I have asked her to bring some certificates. It may be taken up tomorrow or day after, my lord. I'll make my submission.
My lord, the main matter is already pending before the trial court. It is their day after tomorrow. So this writ petition may not be delayed on this case. The question was very simple by this placed by this honorable court to the respondent.
We have to give them an opportunity.
My lord.
You have asked something before this court which was never raised before the family court.
It was raised, my lord.
Or considered by the family court. So we have to look at the material.
Yeah, I press for stay, my lord.
After.
Please, great.
Time may be given.
Yeah.
This is marked after.
Much obliged.
And counsel the respondent. Delete from the caption dismissal. Yes, next.
Great.
For dismissal, serial number 5.
This is 4. Yes, 5.
Serial number 5.
I appeal for the respondent in this case.
Petitioner. Respondent illegally marriage in some auto driver photos ಎಲ್ಲ ಇದೆ ಅನ್ನ ಸ್ವಲ್ಪ ಫೈಲ್ ಮಾಡಕ್ಕೆ 1 week ಟೈಮ್ ಇದೆ ಈಗ ಪಿಟಿಷನರ್ ಬಂದಿದ್ದಾರೆ.
No, please come to the impugned order. Which page number?
My lord.
Impugned order.
According to you, wife is already married.
Illegally married. Some auto person. Auto driver. Petitioner is present. Petitioner is present.
File these documents.
There are 2 children, in fact. Your Lordship, kindly, from the date of petition till today, he has not paid not even single pay.
Whether she is married or not.
She is not married.
Legally married.
There are 2 children, in fact.
Let him file the document.
On the basis of the photographs, it cannot present she has married. What is the, where is the material?
I have not said anything.
That is why, no, my lord.
Said, let you file. You have an opportunity to file your
Fine,
objection.
very well. Now let him deposit the amount. Since from date of petition till today, there are minor 2.
Stay in this.
There are no stay.
Then why did you not file your execution?
There are two children,
Matter.
minor children.
This is matter on 9th of September at the request of non-counsel petition.
Cell number 6 for orders matter.
Delete from dismissal. Yes, 6.
Cell number 6. Ms. Salma for petitioner.
Proof of service is filed, Your Lordship. And they have come up with the criminal petition, Your Lordship, and state the criminal case against them, Your Lordship, in the criminal petition number 10026, Your Lordship. They have stated that they'll settle the matter in the mediation and they have taken the stay, Your Lordship. Kindly, this matter may be tagged.
Advocate, who is the advocate appearing in the criminal petition?
Some Mujahid, Your Lordship. Same office, Your Lordship, who is appearing for this thing, lower court.
Find out, we'll pass over, so that we'll print the name of the advocate in the cause list.
I'll just give you Mujahid.
Take from her. It is submitted that questioning the proceedings, a criminal petition is filed, and so is appearing to the respondent in the said petition. Bring the
Mohammed
name
Mujassim.
of so and so. Write on a paper and give. Yes, this is matter on 10th of September. Yes.
Refer it to mediation. Your Lordship, refer it to mediation along with this petition.
He should come for referring it to the mediation.
Cell number 7. Ajay Prabhu for petitioner.
No representation for dismissal on 11th of September.
Cell number 8.
Ballots for the petitioner.
Urmila,
Your Lordship had
Urmila.
directed that we may carry out hand summons. I'm filing a memo to that effect. They've been served, my lord. The trial court advocate has been served.
Take that. File is not required. To the memo. What is the name of the advocate?
Chidananda, my lord. Chidananda.
That's why I'm asking in the memos, please mention the advocate's name. We can't understand from the signature what is the, who is the advocate appearing.
Yes, ma'am.
Write the petitioner shall file a proper memo indicating the name of the advocate on whom
Your
they have
Lordship.
served the.
If your lordship permits, I may be permitted to do it right now.
Do it. Pass over. Yes, next.
Cell number 9.
Serial number 9, I appear for the petitioner.
The
last day.
Respondent, my lords. I filed my wakalat today. Kindly allow me to file my objections, my lords.
Objections, what objections you will file?
A lot
This
of
is
blatant-
This is matter on 2nd September. So and so submits that they have instructions to file wakalat. So the counsel for the petitioners has served the copy of the memo.
I filed a memo for having served, my lords.
Yes.
And the petition is also served. But, there is a connected matter, 2330.
List along with so and so.
2330.
Write on the paper and give it to the court officer.
Hearing on interlocutory application. Cell number 10. Manjunathan.
IA number 1023 is filed.
The respondent, so date may be fixed.
Seeking early hearing of the petition. This is matter on 4th of September.
Published.
Cell number 11. 11.
For the respondent in this case, my lord.
My lord, in this
My lord, the
matter-
respondent has filed an application for contempt of court, my lord. My lord, previously, trial court has passed an order on 28th of January 2020.
This court on 22/8/2025 has interacted with the father, mother, and also the child. IA number 102 of 25 is filed by the writ petition is filed by the mother.
Yes.
In that you have filed the IA.
My lord, yes, my lord. I have.
Mother has filed the writ petition questioning the order of visitation granted by the family court. In that, IA number 2 of 25 is filed by the respondent father for seeking to initiate the contempt proceedings as mother is violating the orders of the court and a visitation is not provided to the father. This court on 22/8/2025 has interacted with the child and parents. This court could see that the boy is undergoing tremendous pressure. The reasons for the same has to be find out. Both the mother and father have their own versions for that. In these circumstances, this court deems it appropriate to direct the parties to appear before the to appear before the Bangalore Mediation Center, and on 9th, not on 3rd, 4th, fine.
My lord, I am not in town 3rd, 4th.
You don't have to. They have to go and meet the counselor on 3rd and 4th.
My lord, I would still request on next week or before that. A week after that, may I please request?
Think faster, Miss when?
I'm sorry.
When?
Not faster, but a week after that. Any day after the 8th is
on 10th. On 10th. And 10th, there they have to appear before the counselor, the oblique psychiatrist, and she shall evaluate what are the reasons, and she shall meet the child along with the father. She shall meet the child independently, then along with the father, along with the mother, and along with both the parents. If the counselor feels that counseling is required for the parents also, and what is their state of mind, a report has to be placed before the court. If for further dates also, the counselor wants to interact with the parties, as per the counselor's advice, it shall be done. Evaluation shall be done, and a report shall be placed before this court by the Director, Mediation Center, Bangalore. The Registrar Judicial is directed to communicate the same. This matter after the report is received from the Director.
Cell number 12. Rajaras.
My lord, in this I appear
But
for the respondent.
The
My lord,
order, my lords,
my lord, I seek a week's time to file my objections in this. If this matter may be taken up any time after Monday, my lord, I'll file detailed objections in both the matters.
What is this, sir?
my lords, I have challenged my lords for modifying the quantum of the maintenance one. My lords, the maintenance is order from the date of my lords, the order was put.
Page number, where is the order?
My lords may kindly see Annexure D, page 31. Page 41 is the operating portion. IA number 3 filed by the petition, my lords. 41, page 41.
Where is the operative portion?
41, my lords, page 41.
The respondent is directed to pay interim maintenance of 10,000 per month.
Daughter.
Petitioner number 2 and his daughter.
All the materials known.
Record that the respondent has been paying 5,000 regularly to the petitioner. So the respondent is directed to pay the interim maintenance of 10,000 to his daughter from the date of this order, pending disposal of the petition.
So from the.
What is the IA file?
Lords, the application was filed along with the main petition, my lords, in the month of April 2023.
April
2023.
2023. That is one ground. What is the other ground?
Lords, the maintenance insofar as the first petitioner, my lords, the mother, the wife, my lords, was rejected.
On the ground?
That she is employed.
What is her salary?
And my lords, on the other ground, my lord, that she was granted the maintenance in DV proceedings.
No. What is her income?
My lords, on the date of filing this petition, my lord, she was working as an assistant teacher. My lords, on the date of order, my lord, she was relieved from her services because it was on a contract basis. My lords would kindly see
What was her salary?
14,000.
What is husband's salary?
My lords has disclosed this, my lords, 45,000.
How much is paying in the DV proceedings?
He's paying 6,000, my lords. That also, my lords, interim order was, my lords.
So 6,000 is paying there.
Yes, my lords.
10,000 now he is asked to pay to the daughter. It's coming to 16,000.
16,000.
His salary, take home salary is how much?
My lords, he discloses it, my lords, 46,000, my lords, 45,000 at page 59. And as per the calculations, my lords, it is average monthly salary would come at 58,000. Average monthly salary, my lords, would come around, my lords, 50.
Already almost 30% of the salary is granted.
My lords, yes.
What else?
My lords,
No enhancement.
my lords, the problem is this, my lords. She's granted 6,000 from DV proceedings, my lords. And my lords, this proceedings, my lords, he has not even paid any money. And my lords, and the other ground on which we are challenging is, my lords, it is ordered from the date of the order.
That we will see.
Yes.
As far as enhancement is concerned, already enough maintenance is granted.
Yes.
So we will not grant any maintenance, nor we will enhance the maintenance. But
Yes.
we will make sure, we will make it clear that it should be from the date of the petition.
Yes.
Okay.
That can.
My lord, insofar as the date of the application is concerned, from the date of the petition, there are several facts which were not brought out in the application filed by them. Since the date of estrangement, the husband has been paying rupees 5,000 continuously to her, and which has been accepted by them by way of an affidavit also.
Then in that case,
Subsequently, my
no,
lord.
in that case, from the date of petition till this order, he will be paying 5,000.
My lord, insofar as the application with respect to that rupees 10,000 is concerned, we have filed for a modification, my lord, on the grounds that in the assets and liabilities that were filed by them, the bank statements were tampered. All the details had been provided. Along with that, a section 340 application is also pending before the court. For that modification, my lord, absolutely no efforts are being made to file an objection or even take up the matter for hearing. That apart, my lord, there was another application that was filed before the court seeking educational expenses. In the meanwhile, my lord, they approached this honorable court and took a direction that that application has to be disposed of, which was a subsequent application after the modification IA. A direction was sought by this honorable court to get the matter disposed of in 15 days. In May 2025, during the vacation itself, my lord, the family court went ahead and disposed the matter immediately within the stipulated time, and subsequently, my lord, the matter was, the issue was not even enhanced because in the rupees 10,000 that has been granted to her, it included the educational expenses, the maintenance and the educational expenses. My lord, if that application binds me that if the modification is heard and subsequently it is cleared, and subsequently if the honorable family court finds that it cannot be modified, under those circumstances, I will be bound to make the payment, my lord, and I am ready to make the payment insofar as, but let the applications be cleared off, my lord, because absolutely no efforts are being made. Wherever section 340 has come in, all the three places assets and liabilities has been filed, bank statements, wherever there is a higher amount, it has been tampered.
I'll clarify this order. Modification application, if it is pending, let the court decide.
My lord, this the decision of this honorable court in this matter will have a direct implication, my lord.
Because you are seeking modification basing on some suppression of misrepresentation of facts. In those cases, this order will not come in the way. As of now, as it stands, the order holds good. Only thing is not from the date of the order. It should be from the date of the IA. And if it is admitted, calculation memo, both of you file before the court. If you have already paid 5,000, in this 10,000 amount, that 5,000 will be deducted and remaining amount you're bound to pay.
My lord, this 10,000 amount itself is subject to modification there.
That is basing on some suppression and misrepresentation of facts with regard to, you have filed some application before the court. Once I'll leave it open. If it is decided by the court, let it, basing on that, the order can be modified.
My lord, the matter may be taken up. Detailed objections I will file, my lord. On Monday, I will file the objections. I'll put that on record before this honorable court, along with the dates. I'll put that on record. Despite that, this honorable court feels that I'm in the hands of this honorable court, my lord.
To understand it. Now, this is an interlocutory order. For that, first of all, basic rule is there are no, the objections are not at all required before this court, because the court is dealing with an impugned order basing on an IA, basing on an affidavit, affidavit and your objections to that. What other material, like, why should the court look at it? This practice of objections, we should, in a writ petition, we should stop. Waste of court's time, nothing else.
My lord, in which case I will not file the objections, but I will do a detailed hearing of the matter. Let me be prepared along with all the order sheet, I mean dates of the order
What
sheet.
you're not understanding
Monday,
is
my lord.
the result will not change, but for your satisfaction.
Very well, my lord. Monday, if the matter may be taken.
So far as my lords 20.1, another matter.
Yes.
That my lords,
12.1.
he sought 12 point, I'm sorry, 12.1, I'm sorry. Lords, he sought for
Anyhow, she is asking time.
educational.
Again, why should we waste time?
Great.
Yes, Tuesday.
If any date is fixed.
29.
Much.
Cell number 13, preliminary hearing, cell number 13. Satyamaya SK for petitioner, Basavaraju M.
From filing the bank statement, it should not take more than 2 minutes, my lordship.
Where are they? That's what I'm saying.
Sure.
No representation for the respondent.
I'll serve it and then file it.
Counsel for the petition is present. It is submitted that as per the order passed by this court, the bank statement is ready. They will serve on the respondent and file and will file the same. This matter on 10th of September.
Cell number 14. Omkar Basav Prabhu.
Or the petitioner in this matter, aggrieved by the quantum of the interim maintenance ordered in favor of the respondent number 1, 2, and 3, my lord, this petition, rupees 10,000 towards respondent number 1 and rupees 8,000 towards respondent number 2 and 3 each. So put together, my lord, an interim maintenance of 26,000 is awarded.
What is your salary?
My lord, he is a businessman, my lord, but currently his business is down and under. As per the
when it was all right, what was your income?
My lord, as per the income tax returns produced before the court, given the substantial loan repayment that the respondent is obligated to make, my lord, his source of income stands at approximately 4 lakh rupees, my lord.
Per month?
No, my lord, per annum. Per annum. Lord, the respondent number 1.
The court to pass this order, please come to the
my lord, on perusal of the impugned order, simply reads that the interim maintenance sought is, my lord, kindly page number 22. There is no reason per se given by the trial court. The trial court simply assess what is sought.
petitioners mention the school expenses.
Yes. Lord, page number 23, my lord, without assigning as to under what basis such maintenance is ordered. Lord, 10,000 rupees in favor of respondent number 1 and 8,000 each in favor of respondent number 2 and 3 is passed. In addition, my lord, may I kindly be permitted to submit that the respondent number 1 is guilty of suppressing material facts before the court, my lord. Kindly, page number 52 may be perused, my lord. 52 is the bank statement that the respondent number 1 herself has produced before the court, my lord. Lord, in her statement, in her assets and liability, she contends that she has no income. However, my lord, on perusal of this bank statement that she has produced before the court, Lord, she makes recurring income, my lord, to an extent of 16,500 and.
No, that is for her. What about the children? Yeah. For children, you have to pay.
Absolutely, my lord. My lord, my client is aggrieved by the quantum of the compensation rather than the order of interim maintenance itself, my lord. Given the outstanding loan commitments, my lord, he is unable to bear this quantum. So
Pay 15,000 to all the three.
yes, my lord, I'll fairly concede to that, my lord.
Agreed with the order passed. In I number 2 in criminal miscellaneous number 830 of 2022, whereby the court had granted 10,000 to wife and 8,000 each to the children, total 26,000. The husband is before this court. Learned counsel appearing for the husband submits that the court, without considering what is the income of the wife, what is the income of the husband, has granted this amount. The learned counsel has drawn the attention of the court to the reasoning part, wherein there is absolutely no discussion with regard to the financial capacity of the husband. The amount that is granted is 26,000. It is submitted that as per the income tax returns, his yearly income is 4,000, 4 lakhs. Considering that, considering the same, they shall be stay of all further proceedings on the condition that the petitioner shall pay an amount of rupees 5,000 each to all the petitioners by 5th of every succeeding month, and the arrears at 15,000 shall be paid within 8 weeks from the date of receipt of the copy of the order.
My lord, I'll deposit already during the pendency of the proceedings prior to passing of the order. My client has paid a sum of rupees 1 lakh.
If any amounts are paid in the interregnum,
Remaining, my lord, 50%
in the any amounts are paid in the interregnum, the same shall be deducted and the remaining amount shall be paid either the amount by 5th or this arrears. The stay granted by this court stands vacated. Hand summons on the counsel for the respondent and shall file a memo to that effect by 8th.
May I seek for 10 weeks time instead of 8 weeks, my lord, kindly?
Already too much of indulgence, the court has done nothing more. But by 8th of October, if the memo is not filed, even on that ground also, the stay shall stand dismissed. Stay shall stand vacated.
I'm grateful.
Cell number 15, Harsh Kumar Gowda for petitioner.
I appear for the petitioner. My lord, the petitioners are the maternal grandparents, my lord. And my lord, the petitioner's daughter got married to respondent number 1, my lord.
Order, impugned order,
My lord, the impugned order, my lord, is at annexure D, my lord.
page number.
The petitioner, they filed the compromise, my lord. The compromise petition has been accepted by the trial court, my lord, against which petition has been preferred, my lord. The facts of the case is that, my lord, the petitioner daughter was married to the respondent number 1, my lord, in the year 2020, and she commit the suicide.
Maintainable.
She commit the suicide, my lord, and
How the petition is maintainable?
my lord,
You have to file a suit. If you are not a party to the compromise.
I am the party. I am the party to
If you are a party, go before the very same court if there are any reasons for that.
My lord, the compromise, the terms of the compromise is that, my lord, to show the child on the last week of every 2 months, my lord.
For violation
And there
of
is
the
there is no
compromise,
default.
you cannot come before the court.
And there is no default clause in the compromise petition, my lord. And now,
But
my
why
lord.
did you sign?
Yes,
Why
my
did you
lord.
sign?
My lord, they are the illiterates, my lord. They are signed. Kindly see annexure C, my lord. It's a hardly
That is
half
not,
page,
that
half
is-
page compromise, my lord.
That is not
And
law. Why
and
did
there
you
is,
sign? Did anybody ask you to sign?
my lord,
You don't even say no fraud, no coercion, nothing. And still you want this order to be reviewed by this court.
and my
In
lord,
a-
they're not allowing to see the child, my lord. That is the.
But we can't help it. There is a ways
And here, my
means.
lord, the reputation is maintainable, my lord.
So, where is the law on that?
My lord, I will produce the
The
order.
latest judgment of the Supreme Court.
Yes, my lord.
There is a latest judgment of the Supreme Court that you cannot. So you can't get any other judgment.
But earlier, my lord, this honorable court itself has.
That is long back. After
yes,
that,
my lord.
several orders. I passed several orders.
And my lord, and here, my lord, there is no default clause, my lord.
That is not the
they're not
lookout of the
allowing.
court for in this. Please come. Simply there can't be any default. In a compromise decree says that so and so party has to do so and so act. If there is any violation, you can. It is a compromise. It's a decree. it can be executed. Why do you require a default clause?
But
as per the terms of the compromise,
Yes,
if there
madam.
is a clause that they should, you should have the visitation on so and so date. If there is violation, you will file the execution. On that ground, now for
My
inserting,
contention is that, my lord, that default clause has not been,
not required. The default clause is not required.
by
Parties have
making that
agreed.
observation, my lord, liberty may be reserved.
Please do not ask the court to do something which the court is not, has no jurisdiction to interfere with. In this writ petition, an order, a compromise, the parties have entered into a compromise before the Lok Adalat on 8/3/2025. That order is questioned before this court by way of the present writ petition. Learned Counsel submits that it is a cryptic order, a cryptic memo, a compromise, and the default clause is not included. And in view of the same, the petitioner is not able to see the child, and the order of the compromise decree is not executed, and the compromise decree is not implemented. Uh, the writ petition that's filed before this court under 227 of the Constitution of India is not maintainable. Petitioner is a party to the compromise decree, and it is not even his case that he had signed the same in your by undue by any fraud is paid by on him, or there is any coercion. Just because there is no default clause and the children are not, the father is not permitted to exercise the registration rights, that cannot be a ground for this court to interfere with the compromise decree. If on any of the grounds, if they are agreed by a compromise decree on the ground of fraud, coercion, and other things, the remedy to the parties is to go before the very same court, but not before this court. In that view of the matter, this court do not find any reasons to interfere. Accordingly, dismissed in liberty to the petitioner to avail the appropriate remedy. Yes.
Cell number 16, Maltesh for petition.
A petitioner, madam. This is the husband's petition. And on the Milord, the wife filed the Milord divorce petition. Milord, on Milord, 15/6/2024, in page number 18, Milord. An ex parte order came to be passed, Milord.
Where is the impugned order?
Milord, impugned order is, Milord, in page number 24. Before that, Milord, Lakshmi, kindly see in page number.
If you just see this, then you can state
Yes,
the
ma'am.
facts. It starts where 24.
24, Milord. It starts from 24. Milord, operative portion, Milord, in page number 27. Monthly interim maintenance of rupees 25,000, and Milord,
There are
litigation.
two numbers to this. I don't know which number is.
27.
IA number 2 filed on behalf of the petitioner so and so is hereby allowed in part.
Yes, Milord.
She is entitled for monthly maintenance of 25,000 from the date of the application till disposal of the case, and one-time litigation expense of 25,000.
Yes.
This order is passed when?
Milord, on 2/5/2025.
Yes.
Milord, before that, Milord, an ex parte.
This is the impugned order.
This is the impugned order, Milord. Milord, in page number 18, Milord, last week kindly see on 15/6/2024, an ex parte order, Milord, came to be passed. Directing, Milord, the respondent to pay 30,000 towards the, Milord, education expenses of the children. Milord, after that, Milord, notice was issued, and Milord, the respondent appeared in person. And Milord, if not filed, Milord, the objection, and Milord, assets and liabilities also not filed. And later that, Milord, he engaged the counsel. In that, Milord, Lakshmi kindly peruse, Milord, there also, Milord, objection is not filed. After that, Milord, an impugned order, Milord, came to be passed. Milord, he is a owns a, Milord, condiment shop earlier, Milord. Now, Milord.
I'm not concerned with the other things. Why did you not file your statement of assets and liabilities in spite of repeated opportunities? And why should this court interfere with this order?
Milord.
Left to the court.
Milord.
And what did the Honorable Apex Court has discussed with regard to this
Yes.
kind of non-complying with this condition.
Yes, my lord.
An adverse inference has to be drawn.
Please,
Court
please.
has drawn, we will not interfere.
No.
What you cannot do before the court.
Yes, my lord,
that
it is,
this court also will
my lord,
not
yes,
go
my
into
lord.
that.
Now, my lord, he works as a, my lord, he works as, but he doesn't have any,
I think this is high time we should stop this practice. What you are not, when you are given a opportunity, what you have not done before the trial court. Now, we are only looking at the order. We will not look at any other material. We will only do what is the material before the court, whether the appreciation of the case is proper or not.
yes, my lord. My lord.
Because you have not filed,
Yes,
court has
my humble
appreciated.
submission is that, my lord, let him, my lord, he doesn't have, my lord, source of, my lord, income of pay,
No,
my lord,
who
25.
stopped you?
Yes, my lord, my lord, he failed to pay, he
What he
failed to.
can do before the high court, can't he do it before the family court?
Yes, my lord, but my lord is not properly, my lord, he was guided before the trial court. My submission is this, my lord, it is not his duty to file, my lord, asset side liability along the bank statement. My lord, he lost the job. My lord, entire, my lord, due to, my lord, what he got, my lord, ex parte order, my lord, he lost everything. And my lord, he will pay. He already paid. He paid towards the, my lord, the education expense of the, my lord, children. My lord, Lashme Kaili Peruz, my lord, in page number.
Where is, no, before this court, where is your statement of assets and liability?
Which is not filed. Well, I will file my statement of.
No, why have you come before the court?
Lord, only, my lord, I seeking an opportunity to file before the, my lord,
No,
before the family
I'll
court.
not, I'll
only.
not grant.
Lord, I will file here only, my lord.
No, I'll neither before, at least to show your bona fides.
Yes,
I
ma'am.
thought you must have filed something, nothing. Now, we will set aside this order. Court has already spent so many hours of hearing on that.
No, no,
And this court, another 10 minutes for your case today?
No, my submission, normally he is paying towards the, my lord, the children. My submission is that, my lord, one opportunity may be given. My lord, he doesn't have the, my lord, the.
When did you enter appearance? Date?
Lord, I entered into appearance, my lord, after the ex parte order, my lord, Lashme Kaili, see, my lord.
No, first ex parte order means first time, when is the notice served on you?
Notice, my lord, is served on 23/11/2024.
23/11/2024 notice served on you.
Yes, my lord.
Then when is the IA?
Lord,
order is passed, ex parte order?
Ex parte order is passed, my lord, on 15/6/2024.
15/6/24.
Yes, my lord.
Wow. Without notice, you court has passed an order.
Yes, my lord. Page number 18, my lord.
Yes. Then
after that, my lord, he appeared in person till, my lord, 1/3/2025.
what were you doing from 23/11/24 to 1/3/25?
He not properly guided, my lord. This is my submission. One opportunity may be given, my lord, to file the.
That is everyday story we hear. Just to blame the advocate, nothing else. When favorable order is not there, then problem of the advocate.
Not he is paying, my lord. May be permitted to see, kindly see, my lord, page number 23, order dated, my lord, 1/3/2025. My lord, he paid 22,500, and also, my lord, remaining also, my lord, balance also he paid. Now, my humble submission that, let him not file the, my lord, assets and liabilities along with the bank statement.
Will first pay her 25,000 cost now itself. Then I'll consider this application. For wasting the wife's time, court's time, and giving you, no, just like that casually will not remand. That should cost you something
Yes,
on you.
I will, my lord,
With
ask.
instructions. If he's
No, my
ready
lord,
for
I'm cost, my lord, I will ready to pay, my lord, before the family court itself, to the wife only, my
have to
lord.
set aside this order, she has to come. To entertain this, you have to pay the 25,000. Then only I'll entertain. Otherwise, I'll not even issue notice in this.
Lord, yes, my lord, I will, my lord, I will.
The land counsel for the petition.
Not 25,000, my lord.
Why not?
Some lenience, my lord. My lord, he lost his condiment shop, and my lord,
Court's time is more valuable than anything.
Yes, my lord, but he is ready to pay. But my lord, it should be, my lord, everything.
From here onwards, we should take a strong this thing. Everybody, all the courts, that once you have failed to do something before the trial court, in spite of giving an opportunity, the court shall not interfere. Once we stop this interference, then everything will set right. All advocates will advise properly to the client.
He appeared in person, my lord, in the initial stage.
That is his problem. If they feel that they're very efficient and they can do, land counsel submits that the order impugned is passed, granting maintenance to the wife and the children at an amount of rupees. How much is it?
25,000, monthly 25,000, and
25,000.
educational expenses 30,000.
Educational expenses 30,000 per annum. It is submitted that the petitioner is not in a position to pay. It is also submitted that the petitioner has not filed a statement of assets and liabilities. In several cases, this court is observing that when the judgment of the Honorable Apex Court in Rajneesh versus Neha is very clear that both the parties have to file their statement of assets and liabilities. If it is not filed, an adverse inference has to be drawn. In spite of the same, it has become a practice to the parties to come to this court questioning an order on the ground that the court had passed an order, though they have not filed their statement of assets and liabilities. When enough opportunity is given, when he has not filed, this court generally should not show any indulgence in these kind of matters. Considering the submission of the counsel that he has no financial capacity, this court is inclined to issue notice to the party on the ground, on the condition that the petitioner shall pay an amount of rupees 15,000 to the wife to the wife within 5 days. If the amount is paid, then the petitioner is at liberty to give hand summons, to serve the hand summons on the counsel appearing for the respondent before the trial court, and shall file a memo to that effect. Once the memo is filed, list this matter.
Bill number 17, preliminary hearing B group, Muniswamy Gowda.
For the petitioner wife, my lord. My lord, on the last date of hearing, your lordship had asked me to produce a statement of expenses because they were not elaborated in the list of assets and liabilities of the wife.
Where is the counsel? Have you served on the counsel for the respondent?
We have sent them a digital copy, my lord.
Counsel of the petitioner is present, and it is submitted that as per the order passed by this court, he has filed the breakup of the expenses. No representation for the respondent. List this matter on 15th of September. Yes.
Bill number 18. Pogoji Vijay Kumar.
Appear for the respondent.
Del Raja for petitioner.
The trial court awarding the amount of 6,000 rupees per maintenance interim.
Only 1 month balance is there. I have verified. They will pay that amount. Meanwhile, they will pay in the next of hearing in the coming week. Only 1 month, sir. I have checked. All the payment have been done.
Yeah, we will decide this matter. It's a 24 petition. Argue.
So we are negotiating with that for one-time settlement.
All negotiations before the trial court, not before the high
Okay.
court.
Much obliged.
Not in a petition. Yes. Where is the impugned order?
Annexure A.
At page number 26, ink page number 26. They have sought interim maintenance of rupees 20,000 per month. The trial court has awarded 6 months, 6,000 per month. I'm doing it fully in the APMC. That is
6,000. Your income would be at least minimum 15 to 18,000 minimum wages. 6,000 is a reasonable amount. Please come. The present writ petition is filed agreed with the orders passed in IA number 1 and C miscellaneous number 25 of 2023, whereby the court had granted maintenance of an amount of rupees 6,000 per month. The husband is before this court. Land counsel appearing for the petitioner husband submits that the petitioner is a daily wage worker, and the court had granted 6,000, which is on the higher side. It is submitted that as per the interim order, they have paid the entire amount except an amount for a month is pending. Land counsel for the respondent submits that the court has granted only an amount of rupees 6,000. And for the maintenance of wife, even if he is a daily wage worker, the amount that is granted by the court is reasonable. and no interference is called for. Next, for having heard so and so, so and so. The admitted facts are that the husband is working daily wage labor, even considering the minimum wages at 15 to 18,000. What the court has awarded is 6,000. In the considered opinion of the court, that cannot be held as excessive, and no interference is called for. Accordingly, this court finds no reasons to interfere.
So number 19, Shubhaba Mishra for petitioner Satish.
Last occasion, my lord, was directed my lord to for a visitation, right, madam? We are complied with the orders, my lord. This alone court.
Complied?
They have not complained.
Madam, I'm sorry, my lord. We are complied, my lord.
No, my lord.
Four times, my lord. They have gone visited, my lord.
No, my lord. Only on 28th, she has brought the child. Apart from that, she has not brought the child for visitation any day. She has, in fact, conveyed to our client that she's willing to reconcile and she wants to withdraw the case. And that's exactly why the matter is referred for mediation on 4th of September. So this matter may be deferred for 15 days. If there is any settlement, we will report settlement.
Both the GWC and my lord, family court matter, my lord, they have referred to the mediation, madam.
Passed an order on 24/7/2025.
Yes, ma'am.
For whether we refer it to the mediation or not, what happened to this order? Whether it is
My lord,
complied
yes,
with
my
or
lord.
not?
First day, my lord, we went, my lord. The child was, my lord, he has met with his father, my lord. Subsequently, my lord, his father told that, my lord, no, you should not brought, you only come, my lord. Then we 4 times, my lord, we went and we met, my lord. After that, my lord. Then the matter has come, GWG has come up before the trial court, my lord. The matter has been referred to mediation, my lord. Then family court matter has come, that also referred for mediation, my lord. With the consent of both the parties, my lord, both the matters have been referred to the family court for mediation, my lord.
When is the mediation?
4th of September.
4th of September.
This is matter on 25th of September. It is submitted that the matter is referred to the mediation by the trial court.
Please.
Cell number 28, Mohan BK for petitioner.
For petitioner, my lords. My lords, the respondent was directed to file the memo, my lords.
Yes.
Yeah, I'm for the response. The statement is ready, Your Lordship.
Have you given to him?
He is from Mysore. That is the
No,
problem.
no, my lords, my office is in Bangalore, my lords.
But he is not attending the court.
Then please,
No.
give them. Otherwise, where they will serve the papers?
No, my office is in Bangalore, my lord. My colleagues are there, my lord. Because of some health issues, I am in Mysore. So they could have as well given the copies to my colleagues, my lords.
The respondent is filing the memo. Memo of what?
Memo along with the documents.
He is filing the memo along with the documents. The counts for the, but it is not served on the counts for the petitioner. The respondent is directed to serve the same on the counsel for the petitioner and file the same before the registry. List the matter on 18th of September.
Grateful, my lord.
21, Umashankar MN for petitioner. Rajgopal Naidu.
Appearing for the respondent is above.
Appearing for a petitioner, my lord. My lord, on the last occasion, this honorable court was directed me to take out hand summons, and the acknowledgement has been served, my lord.
Counsel is also here. You can argue. Counsel is here. He is already representing. You can argue.
Yes, my lord, sure. Yes, my lord.
Yes. Where is the impugned order?
My lord, the impugned order is at page number 18, my lord.
The court has passed an order directing you to pay maintenance of 20,000.
Yes, my lord, yes.
What is wrong with the order?
I'm not considering the academic fees of the child of the petitioner, my lord. It comes up to 2 lakh rupees per year. And in the year 2022, my lord, for the academic year 2021 and 2022, the petitioner has given an undertaking before the school itself that his annual income is around 8 lakh rupees, my lord. And the same has been recorded in the writ petition, my lord, filed by him only.
So, how much is your annual income?
Annual?
8 lakhs.
No, my lord. I get a salary of around 43,000
per month.
Per month. That is the only income that I have. Approximately, it is around that, my lord. It is 40.
What happens is,
Yes,
He is
madam.
paying the educational expenses of 24,000. That is, if it is 2 lakh per annum, 24,000 per month. And now the court has directed him to pay 20,000.
My lordship, a word, my lord. I work in a college which also has a school.
Let's see,
I
44,000, 44,000 is what now he is directed to pay. What he is getting,
No, he's been directed to pay only 20,000, my lord, every month.
20,000 maintenance.
Yes, my lord.
He is paying the educational expenses.
No, my lord.
No, my lord, no, my lord.
Saying-
He's not paying anything.
Huh?
He's not paying, my lord. Education expense is not being paid. 20,000 maintenance is being paid, my lord.
You are for the wife, you are seeking enhancement.
Yes, my lord, yes.
Your income is 8 lakhs.
No, my lord. My income is only 40,000 per month. That's around, it will total up to 5 lakh rupees per annum.
And what
Well, for
about
the-
wife? Is she working?
She's getting a rent of 25,000 on record. That assets and liabilities that is filed. There is enhancement which is not revealed here. So that I'm not taking. Even then, she's getting 25,000. The same is even recorded in the order, my lord. If you look at page 32 of the order, my lord, that has been filed before this ink page number 32. In para number 15, they make an observation that she is getting 25,000 as rent from her on this one, and she has a property in her name worth 3 crores. I do not have any property in my name, and I work in a pre-university college. I have also filed my salary before this honorable court. I have for the reference of this honorable court.
Not this.
Okay. It states that I get a salary, net salary of 43,529. Other than that, any other income that they're trying to tell belongs to my father and not me. He is allowed me to stay in his own house, in which the wife and daughter are staying now. They are staying in the same house. He had given me a portion in the first floor, in which they are residing now. I get 40,000 salary. I have been asked to pay 20,000, which I've been paying duly without any default.
Yes.
Lord, with regards to the 3 crore rupees property which my learned friend is mentioning, there is no finding of the family court, my lord. With regards to that, that is my father's property. It may be or maybe not.
First of all, what is the evidence on record with regard to his income?
My lord, my colleague is there. He'll produce the copy of the writ petition, my lord. It is filed by the respondent himself for setting aside of the order of the family court. In that writ petition, there's a finding which says for the academic year 2021 and 2022, the respondent herein has given a declaration saying that his income is 8 lakh rupees before the school.
That comes to, if it is 8 lakhs, how much it is per month?
65,000, my lord. So with 8 lakhs divided by 12, it comes around approximately 67,000, my lord. 66,666 is the actual amount. Approximately 67,000, my lord. And also, my lord, they say that they have given me a house above their house to stay and all of that. My lord, with regards to that, there are a lot of litigations being filed against me, my lord, because they have sought for a temporary injunction in the trial court against me not to enter that particular place. They lock the premises whenever I am out of the premises, and they have been filing multiple cases in the trial court against me, my lord. I also have to bear those legal expenses as well.
Wherein the petitioner and respondent have submitted a declaration stating that the petitioner has got an annual income of rupees 8 lakhs.
Yes, my lord.
Your lordship, that declare now she was getting rent of 25,000, my lord. I was getting, that is what she totally filled in and asked me to signature. Now the husband will never tell no when she is making a, and he told her that it is not to his level. He is getting a salary of 45,000. With his father's aid, he is able to run the family. Now, it is not to this one, my lord. If a person is getting 45,000, if he has to pay for educational expenses only 40,000, how would he even survive with 5,000, my lord? Even if his father has given the property, it cannot be that a married man can go keep asking his father for help every month. That wouldn't happen. Now there was basic this one that she was willing to share from her own this one. He is also willing to
Come to the impugned order. What is the discussion with regard to the financials?
I will file even though I have the
Read the paragraph number 14.
paragraph number 14 in the order, my lord.
Yes.
Yes, my lord. Both parties had filed their affidavit and disclosure of assets and liabilities, whereby applicant having stated that she has no independent source of income, which claimed interim maintenance of rupees 1 lakh, and she is having a girl child by name DN Sanvi Security. She had also disclosed with regard to her job as unemployment. Further, she had disclosed that she is getting a rental income of 25,000 from her parent side joint family property. So this particular makes out that she has an income of 25,000 per month. And then it is on the other hand, he certified that he is a teacher. He is a SDM, or second division assistant.
Yes. We cannot look at that. Now, both the parties have filed their statement of assets and liabilities before the court. Basing on that, the court has even held what is his income. We can't look at some observation in the earlier writ petition. There is nothing to enhance. 50% of the amount is given as maintenance.
Now, with regards to that, he has only given me the consent to
Now,
go and
why are we concerned with it? The statements of assets and liabilities are filed before the court.
yes, my lord.
Court will be governed by that. Yes, please come. Agreed.
My lord, at least like a major amount may be enhanced, my lord, because she's paying rupees 2 lakh rupees per.
The court grant more than 50% as salary as maintenance. Agreed with the order passed in I number 4 in MC number 29 of 2021, dated 21st March 2024. The wife is before this court seeking enhancement of the maintenance. The wife had filed a petition seeking maintenance under section 24 of the Hindu Marriage Act, seeking interim maintenance of 1 lakh per month to herself and her minor daughter, aged about 6 years. It is a case of the wife that the husband is having. The father-in-law is having several properties, and they are deriving a lot of income. And the husband is a owner of a commercial building, having commercial sites and agriculture lands in various districts, and running school under the name and style of Vinayaka Vidya Institution in Srinivasanagar, Bangalore. From his business, he is getting more than 3 lakhs per month. And she sought for maintenance of 1 lakh. It is a case of the husband that his income is 48,000.
3,000.
43,000 per month. The court, by order impugned, had granted 20,000. In the said order, the court has observed that the wife is getting rental income of rupees 25,000 from her parents' side joint family property. And the court, considering the salary of the husband, has granted an amount of rupees 20,000 as maintenance. According to the land counsel for the petitioner, the husband is having several properties, and the court had failed to consider all these aspects, and she is entitled for maintenance as claimed by her. Land counsel appearing for the respondent, husband submits that when his salary is set is 43,000, court has already granted 20,000 as maintenance, and there is no enhancement called for. In his contentions, land counsel for the petitioner submits that in the earlier order, the court has observed that his income is 8,000, basing on a declaration filed before the school. In view of the same, the salary has to be considered at 8,000.
8 lakh.
8 lakhs, but
Per
not 8 lakhs per annum, but not 43,000 as stated by him. Next, having heard the counsels on either side, there is a material on record. While deciding the maintenance, as per the judgment of the apex court in Rajesh versus Neha, court has they have filed the statement of assets and liabilities, and basing on that, the court had considered the salary, and as per the evidence, his salary is 43,000. In those circumstances, the court had granted a salary of 20,000, considering the fact he is getting another 25,000 towards the rent. In these circumstances, this court do not find any reasons to enhance the maintenance accordingly. Discussed.
Your Lordship,
22.
case is being delayed, my lord, if it can a year be
Which year is the petition?
21, my lord.
Which court?
6th, my lord.
Family court.
Yes, my lord.
Yes.
Much obliged.
Number 20. SP Judge for petitioner. Adeline Nancy Prince for respondent.
Before the respondent. My lord, I pray more time for the settlement here. Kindly, it may be have it after 10th of September. So she was unable to come to her office due to child was not keeping well. So we'll produce bills and all. Next week.
Your Lordship, we had.
But they are asking time for settlement.
Kindly, it may be referred for mediation. Your
Better
Lordship.
go before the mediation. That is
Because
better.
there are 2 more petitions pending in the family court. We will refer all the cases for the
parties,
mediation.
It may be.
It is submitted that there is a likelihood of settlement. Party shall appear before the mediation on 9th September.
It may be have it on 11th September. Will
Why?
appear on.
Huh?
My senior is traveling on
11th September.
11th.
Your Lordship, there was a visitation allowed from 10 to 6 on the last Saturday, which went smoothly. Kindly, kindly
as
it may be
per-
extended to 12 to 10 to 9, Your Lordship.
Let it go on.
Let him have the dinner, and because he was
The
very
visitation shall
comfortable.
go on as per the order, earlier order. Yes.
Your Lordship, kindly the interim stay also may be extended.
Stay earlier granted is extended to the next date of.
Because if it is given up
Interim
to,
order granted earlier is
if
extended.
it is
to the
given
next-
until 9 p.m., the child who wanted to stay some more time, grandma could feed him the dinner.
See, we'll see. Yes, next.
That's okay.
Much obliged.
Yes.
Serial number 23.
Paper of the
Vidya,
petition.
yes, for petitioner.
The Honorable
Respondent.
Court asked memo of calculation last time, that how much we have paid as per the order of the court. My lord. We have paid the entire amount, my lord, and we are paying the month.
What he says. According to them, they have paid.
I'm filing my memo of calculation.
View that?
45,000 is the amount due.
Huh?
So 31,700. 21 months, 1,05,000.
31/5/2025, an amount of rupees 55,000 is deposited.
My lord.
Is it included in this?
My lord, there is
But you
a,
are not, 31/5 years it is there. According to them, the total amount is 75,000 and 45,000 is outstanding.
No, my lord. My lord, according to us, it was totally, we had to pay 1,05,000, my lord. We have, that is only arrears, my lord. And monthly, we were supposed to pay 5,000. So we have paid that 1,05,050 we have
Please
deposited.
look at their memo and file your fresh memo.
yes, sir.
The land council of the petition has filed the calculation memo stating that the amounts are clear, entire arrears are paid. According to the land council for the respondent, an amount of rupees 55,000.
45,000.
45,000 is due. Land council, looking at the memo filed with the land council of the petition, shall file his memo of calculation. When?
Next week.
My lord, that 50 which we
This is a
deposited. in the-
matter on 3rd September.
The 50,000 which we deposited in the court is not taken into consideration. So that may be taken into
It is
consideration.
submitted that an amount of rupees 55,000.
50,000.
My lord,
50,000 which is
there is an
deposited.
order directly.
It's their contention. You can come up, 50,000 is not calculated by the respondent. Come up with your memo.
Yes.
Yes.
Cell number 24, Syed Khalil Pasha for petitioner.
My advocate is absent.
Can-
Kindly date may be given.
If you, where is your advocate?
He is not well, ma'am. Is not.
Is it, how many times I have told that you cannot represent before the court?
He instructed me to go and take the
What
date.
instructed? No, what is happening? There is a cause list. First of all, from tomorrow onwards, let any of the parties not enter into the court without an order of the court. No representation for the respondent. Let counsel for the, on both the sides. List this matter for dismissal on 3rd September. Yes, 25.
25, Rohit Ashwa Banakar for petitioner.
The
29
respondent in
B.
this case. Petitioner, madam, kindly pass over. Senior will be appeared.
Pass over.
230, taken upon 230, madam. Senior will appeal on through VC.
It will come, accordingly it will be called. Yes, 26.
I appear for the respondent in this case. I have filed my wakalatnama today. I have a statement of objections to file in this case. I'll file it in the registry, or I may be permitted to pass it.
What are the objections?
My lord.
What is the, first of all, let me look at the impugned order.
Yes, my lord.
Please, my lord.
The lordship will file.
The matter in nutshell is this, my lords. The petitioner is the father seeking for the visitation rights of his,
Where is the impugned order?
my lords would get the impugned order at page 29, my lord. Before that, may I give a small gist of this matter, my lord?
No, let me look at the
Please,
impugned
my
order.
lords,
then.
page 29, 29, my lords, Annexa A,
This is MC,
MC, my lords.
IA order.
IA.
What are two IAs?
One seeking stay of the proceedings in view of the fact that there's a criminal prosecution initiated by the wife against the petition under allegations of POCSO. That is pending. So we thought, my lord, in view of the fact that the trial is not committed, it will affect the defense in the event if we proceed with this case. So we have sought for the stay of the proceedings in the MC. That was rejected, IS6. That we are not pressing, my lords. Only 7 seeking for visitation rights.
Number 6 under section CP so and so are hereby rejected. Both are rejected.
Both are rejected, my lord.
Visitation also rejected.
Yes, my lord.
Yes, my lord. Visitation was rejected.
Then on what ground you are before this court? What are you pressing then?
6, I am not pressing, my lord. 6 is for stay of the proceedings. I am not pressing. 7, yes, very much, my lord. I am pressing for 7.
7 is what?
For visitation rights, my lords.
By whom?
By the father, who is inhumanly accused of POCSO on the same, I mean, with the daughter, my lord, of a child.
When was the complaint given against the daughter?
Well, a complaint was given on
By the-
22/17,
24/8.
24/8/2022, my lords.
24?
24/8/2022.
A statement is recorded by the.
Yes, my lord.
164 statement.
Recorded, my lord.
You have that?
I have it.
Pass on.
No, 164,
Recorded.
not 161.
164. Page number?
The lordship may turn to page number 100, my lord.
You gave him the set of papers?
Yes,
Yes, ma'am. Just over here, sir.
100.
Page number 100 is the translation, my lord.
That is 161, my lords.
It's not 164.
The 164 statement I don't have yet, my lord. I'll submit it.
But you please.
I'll submit it.
But independent of that, my lords. At this stage, independent of that, my lords. My lords would have come out on
What is the age of the girl?
She is now 9 years, my lord.
9. At that point of time, she was
At that point of time, she was 3-4 years old.
3-4 years. My lords. In fact, in my short practice, I think this is the 14th or 15th POCSO case which I am conducting trial, my lord. Similar allegations. If there is any marital dispute between husband and wife, they shoot over the child. In
Not
this
such
case,
blanket
in this
allegations
case,
ought not to be made.
No, let me finish. Let me
Whatever
finish.
it is, it ought
I am
not to be.
I am the lawyer who is prosecuted rather.
Those are not the facts of the
I'm
case.
defending.
His practice is
My lord,
not the fact
no,
of this
this of the
case.
fact. What I'm trying to submit, my lord, is this. Many cases, my lord, now they are shooting, mothers especially are shooting over the shoulder of the children, my lord. The beautiful case they have called is POCSO. Earlier 498A was said, that is over now. Supreme Court has said they plugged 498A. DVAT came, that's all plugged. Now POXO. My lords, my friend has produced the FIR, my lords. If your lordships kindly see the allegations, my lord, prima facie will make out it is absolutely false case.
Page number? FIR is where?
In his objections, he has produced
Page
it.
number 55, my lord.
Translation of it?
Translation.
It is in English only, my lord.
Oh, complaint is in English?
Yes, my lord.
Yes,
First information in English only.
I beg pardon. I'm mistaken. FIR is at page number 69, my lord. Translation, your lordship will find at page number
24/8/2022 is the complaint.
85. Yes,
Before that, any other case?
my lord, a MC case was filed
By whom?
by the wife
Seeking?
seeking a dissolution of the marriage
On the ground of?
on the ground of cruelty, drug abuse, cruelty. The POXO had not yet crystallized because we were informed by the child, but we were not sure. The child was sent to a psychologist. Your lordship will find at page number 63.
Let
Is
me
a
first
psychologist
complete this,
59, my lord.
First complaint. Let us.
Yes, my lord. The
Please,
complaint, your lordship will find at page
73, my
number
lord. May I read, my lord?
85. 85 is the translation.
Allah, FIR is there.
I
English in
will-
English. First information in English.
No,
Page
I will-
73.
I will read.
Please, my lords. If you are unreally unspeakable, so
That's why the file is so fat, because everything is translated.
English ಅಲ್ಲಿ ಇದೆ ಅದು. 73 page ನೀವೇ ಹಾಕಿದ್ದೀರಿ.
चीज चालू. She's reading the FIR, page number 85 is the statement of objection for the petition. My objection. Petition.
So on 23/2/2022, age of the child is 3 years.
3 years.
No, this case is pending from 2022.
Please, my lords. Now charge sheet is filed is pending trial, my lord. Of course, in the criminal side. May I request your lordship to kindly turn to page 100.
No, the POCSO matters, they're taking years together.
In fact, we want to close it early, my lord. Now it has come up for the discharge.
No,
I
no,
mean,
generally there is a timeline for that.
by and large, no timeline, but fortunately the court,
6 months?
by and large, my lord. No, it may take little time also because of the reason, it depends on the witnesses.
No, but even if it takes more time, 22, we are in 25, more than 3 years complete.
Yes, he's been fighting. 1 second, my lord. Your Lordship, kindly turn to,
Which court this
is in sessions for special court, my lord.
FTSC 1.
FTC 1.
FTSC 1 and in Court Hall 1.
File,
Fast track court, page
Fast
1.
track court 1.
And
Where do you see, where do you get that?
Your Lordship will get it at page 132. They have filed a discharge application. On that, it's getting delayed. The discharge
Not
application is
delayed,
produced.
not because of discharge. There was a transfer of judge and therefore, and there are a couple of other applications which he had to file. They had come up for this before Honorable High Court, my lord, seeking further investigation. It was done and FSL clearly disclosed absolutely no material found, my lord, in the.
PSC 1,
Yes, ma'am.
additional city civil and session judge.
May I request the Lordship to kindly turn to page 100 of the objections. 161 statement, though for this child is not contemplated. Nevertheless, my lord, the falsity of the case is clearly disclosed. 3-year-old child, it's a baby. And your Lordship may kindly see the answers she is allegedly have been given.
It says 5 years.
3 years, my lord, then.
No, no, look at 101.
Yes. '22. Even otherwise, it's unthinkable for such a small baby speaking all this. And it's clear, mother is nothing but tutored. That I can tackle it in the trial. There's that apart. Prima facie, my lords, can a small baby child, can she say all these things?
So,
and in the end, she would say, you also may kindly see.
What's happening from 22 to 25 with regard to the
Yes, my lord,
visitation?
that
With regard to visitation.
it was not given. You have been hesitating.
This is the first time they have applied, Your Lordship.
Yes, because what happened? The Rosh may kindly envisage what happens when such a heinous allegation is made against the father, my lord. He was fighting in the sessions court. Earlier, he was arrested, and his property, various other things was, my lord. He was really scared, and she was making all sort of allegations. She has filed another FIR that he had engaged the services of investigator, my lord, against which now one FIR is filed. And basically, what had happened is, it is also the record. She was earlier married in USA. She had disclosed, she had not disclosed it. She got married to him, and that triggered off, my lord. And we inquired it. She went out, and she only says, I walked out of the marriage, and all these things have come up later, my lord. And for that, he has filed an FIR. It is not registered, and we have filed a petition seeking the registration of the FIR. That I'm not bringing to your lordships here, but I'm trying to submit that what triggered off and how this law is misused. And your lordship may kindly see the reason why this application is rejected is because the petitioner may harass the victim. It may stress. That's the only liner. I will just take your lordships only to that portion of the order.
No, why I'm not, one thing I'm not able to understand, why the statement of the girl is not recorded by the concerned judge.
Well, it will be recorded, but it will not given to us, my lords.
This is recorded.
It will be recorded. 164 is recorded. It will be, it is a protocol, man. It is recorded in almost all the cases. In fact, he was the prosecutor opposing me in the trial earlier.
No.
He was a special prosecutor. Or
No, no,
one
no,
of,
no.
you have marked 302?
No, no, no.
No, in this case, you appeared, no?
Wrong number.
No, sir, in this case, you appeared against me.
I appeared in the.
Yes.
When notice was issued to me in
Video,
bail.
doesn't matter.
Because
take
my
different roles.
Senior, Mr. Kiran does not know, but I know we opposed each other. We pounced on
I
against each
appeared
other in
when
that
notice
case.
was issued to me in bail. I don't practice on the session.
Yes, in bail he appeared, yes. But nevertheless, he did appear in that case. My lords, may I kindly see the order for rejection.
I think we'll have this matter on Tuesday. We'll hear the matter on Tuesday.
Wednesday, your lordship.
Wednesday. Photos. Send it to the PS.
Is it further hearing, my lord?
Huh?
Further hearing? Please.
No. Yes.
Serial number 20.
My lords, if I may be permitted to make a mention, my lord. List 1, serial number 8.
Can you make a mention now?
My lords, your lordship had
In
heard
the
us.
middle of the list, you can't make a mention. Yes.
List number 2. Serial number 1 for dismissal. List number 2, serial number 1. R. Lakshmana for appellant.
I appear for the second respondent.
Yes. What is this about?
Blood case of injuries to a 19-year-old boy.
Seeking enhancement.
Simple injury, man.
Seeking enhancement.
Seeking enhancement.
What is granted by the court?
That 70,000 is granted global compensation, out of which 43,244 is the medical bills. Doctor is not examined.
Some 2,81,000. Oh,
So
there
that is
are
the
two
another
MBCs.
matter. Two matters. This is
This MBC
pertaining
is?
to MBC 6988 of 2018.
18.
That the finding is at para number 15 and page number 12 of the judgment. Exhibit
20,
P5.
Page
Exhibit
20,
P5.
para 22.
Page number 12 of the judgment, para number 15. Exhibit P5 wound certificate issued by Navachetana Hospital reveals that PW1 has sustained lacerated wound over the upper lip, loss of left upper incisor, abrasion over the left forehead, and angle of the left eye, and fracture of the
I'm not
upper
able
third
to
of
get
the
it.
right femur.
Are you
Exhibit-
referring to the judge about this award page? Page 12? Or
Page
the-
12, my lord.
Where are you reading at page 12?
Page 12, in the 10th line, my lord.
Paragraph number?
Paragraph 15. 15,
Yes.
it continues at page number 12.
Exhibit
Further,
P5.
Exhibit P11 wound certificate issued by Navachetana Hospital reveals that PW2 has sustained abrasion over the left cheek, abrasion over the left elbow, deep incisor abrasion, and the left thigh abrasion, and over the scapular region. Exhibit P12 discharge summary reveals that PW2 has taken treatment at Navachetana Hospital as inpatient from 12/10/2018 to 15/10/2018. Further, Exhibit P18 and Exhibit P23 MLC extra reveals that the MLC was registered at Navachetana Hospital on 12/10/2018. Exhibit P19 reveals that the police intimation so and so. Totally 70,000 is granted, madam.
That calculation, where do you get?
Calculation is not there. Global compensation of 70,000 is granted, including medical bills of 43,244.
That is at paragraph number 22. No, not 22.
Paragraph number 22, madam.
Please read 22.
That I'll read at page number 18. Discharge summary, Exhibit P13, notarized copy of the election identity cards also, and the medical bills 5 in numbers, so the tune of 43,244, and Exhibit P15 is the medical prescription 4 in numbers. PW4 MRO has produced Exhibit P22 inpatient case sheet at Exhibit P24 and X-ray film. In the cross-examination, PW2 has denied the suggestion he has produced the created medical bills PW2 has admitted that he has not produced the document with regard to his avocation and income. On going through the documents, it is clear that the accident
No,
petitioner has sustained.
43,244 are for the medical bills. Then what about the other heads?
Other heads, 16,000 changes granted.
Hmm.
Can be enhanced by another 25,000.
So what we do is, this is for the medical bills. We'll say for transport, conveyance, 10,000. Pain and suffering. Which year is accident?
2018.
What is the income?
He claims
And
20,000,
notional income?
12,500.
12,000?
12,500. He has claimed 15,000.
Along with the legal expenses, it is coming to 1,05,744. Agreed with the award passed in MVC number 6988 of 2018, dated 10th December 2019, whereby global compensation of 70,000 is awarded by the tribunal. The claimant is before this court seeking enhancement of the compensation. The next para. This case has come up before this court on came up before the coordinate bench. There is no representation on 6/6/2025 as well 11/7/2025. Hence the matter was directed to be listed under the caption dismissal. Today also there is no representation on behalf of the appellant claimant. Hence, as this is a appeal of 2021, this court is inclined to consider the same on the merits of the matter. Next para. The claimant had sustained, as per the wound certificate, he has sustained lacerated wound over upper lip, loss of left upper incisor, abrasion over forehead, and angle of the left eye, and fracture of the upper third shaft. There is a fracture.
No, madam.
Loss of left upper incisor, abrasion over forehead and angle of left eye, and fracture of upper third shaft of right femur.
That is pertaining to other case. Your Lordship kindly take to para number 22.
Para number?
22.
Oh. Yes.
22 at page number 18.
As per the wound certificate,
it doesn't say anything about the fracture. Abrasion over the right scapular region.
Where do you get that?
Para number 22 at page number 18 of the judgment. We'll at the 10th line. On going through the documents, it is clear that the
as per the strike it off all that. As per the according to the claimant, he has sustained abrasion of the left cheek, abrasion of the left eyebrow, deep linear abrasions of the left thigh, and abrasion of the right scapular region. And he has taken conservative treatment at Navachetana Hospital as an inpatient from 12/10/2018 to 15/10/2018. Further, there is no evidence on record to prove that due to the accident injuries, the claimant had sustained permanent disability, which affected his earning capacity under such circumstances. By considering the injuries sustained by the claimant and treatment taken by him, the court had granted 70,000 as global compensation, including the medical expenses of rupees 43,244. Then counsel appearing for the insurance company submits that the court, though no evidence is adduced before the court, and basing on the evidence, the court had rightly granted the compensation, and there are no grounds to interfere. Expire having heard the counsels on either side, produce the material on record. The claimant had not examined the doctor, nor any other evidence is placed before the court with regard to disability. As far as injuries were concerned, concerning the simple injuries, the injuries sustained by him, don't say simple, injuries sustained by him, this court under the head of pain and suffering was inclined to grant an amount of rupees 30,000. He has spent 43,244 towards medical bills, and this court has already granted, and this court finds no reasons to interfere. This court is granting an amount of rupees 10,000 towards the attendant, nourishment, and so and so. Then this accident has happened in the year 2018. For a month, towards loss of income, this court is granting an amount of rupees 12,500. In the light of the law laid down in Mekala versus so and so, towards legal expenses 10,000. Altogether, the claimant is entitled for an amount of rupees 1,05,744. Accordingly, the appeal is partly allowed, enhancing the compensation from 70,000 to so and so.
Cell number
Enhanced
2,
amount shall carry 6% interest.
P. Mahadev Swami for appellant, Manjula Tejasvi for respondent.
Appear for appellant, madam.
I'm for the
A case
respondent.
of injury for enhancement.
Yes.
And regarding the liability to the
Liability is on what ground?
the driving license. Madam.
He was a minor, your lordship. The minor was driving, riding the two-wheeler, and there is a judgment of this honorable court. I may kindly be permitted to furnish a copy.
Take that. Yes.
Yes, your lordship. I may kindly be permitted to read it. Para 9, your lordship. For applying the principles of.
I saw this. The thing is, we are talking about in Swaran Singh's case, it's about the violation of the terms and conditions of the policy with regard to the driving license.
Yes, your lordship.
No, whether it is a minor, whether the owner has given the vehicle to the minor, whether to somebody else, what's so happened, he has violated the terms and conditions of the policy.
That I may kindly be permitted to read this paragraph that they have been discussed about that also in this, your lordship. For applying the principles of
The
pay
whole
and.
purpose of granting pay and recovery is to take care of the
Your
third
lordship,
party.
my understanding is this, your lordship, which has been held in this case also. Minor is not at all qualified for any driving license. So as such, it doesn't fall under section 149 clause 2. The person who was holding a license, if he violates, that is found to be driving some other thing.
Not having a driving license is driving. Then that is what
Minor is.
No, I'm saying.
Yes,
a
your lordship.
person who is not at all having a driving license.
Yes, your lordship.
And a minor, he cannot drive. Even a person who is not having a driving license also can't drive.
The only difference is, your lordship, in case of a minor, he is not at all qualified. There he is qualified but was not holding the driving license. That is the difference that makes.
How does it make it a better case?
May I read this paragraph, your lordship? For applying the principles of pay and recovery as per.
Para number?
9, your lordship.
Yes.
For applying the principles of pay and recovery as per subsections 1 and 2 of section 149 of the Motor Vehicles Act 1988, if any of the conditions is violated, though insurance company can be exonerated from the liability, but the order of pay and recovery can be made. But in the present case, while considering subclause 2 of subsection 2 of section 149 of the Motor Vehicles Act, in the case of a minor boy of 16 years old who was riding the vehicle and caused the accident, this proviso is not applicable so as to say that terms and conditions of the insurance company are violated, where a minor boy under the age of 16 years cannot be said to be a qualified person to apply for driving license. It cannot also be categorized that he is not duly licensed so as to come within the ambit of subclause 2 of subsection 2 of section 149 of MV Act, when a minor boy of 16 years old inherently is not a qualified person so as to apply for driving license. Therefore, the principle of pay and recovery is not applicable in case minor boy drives the vehicle and causes the accident. So, Your Lordship, today actually I'm not keeping well. If Your Lordship kindly post the matter on Monday, I think I have come across with one apex court judgment also on this. I'll just verify that also, Your Lordship.
My lord, on the apex court judgment in the 2011 ACJ
ಅದು ಹಳೇದಾಯ್ತು.
1677.
So recently on the other one.
Because it is diluting it again with this principle. A person who is not qualified, a minor, is not qualified. Both, it doesn't make any great difference between the two.
I may kindly be excused, Your Lordship. On that point, I have got a different understanding.
It's not
That's
about
only
understanding.
the basic
You're-
thing is
so
a
basing on
person
this judgment.
qualified is different. Not qualified is different. He was qualified to drive, but he was not holding the driving license is different. What section 149 clause 1 and 2, pay and recovery barbekadre, he was not holding a driving license. That means he was qualified, but he has not obtained for it. That maturity level, it's that what matters, Your Lordship. Here, he is a minor. He is not at all qualified. Even if had he applied it.
It is a mistake of the owner of the vehicle. And the whole purpose of pay and recovery is to take care of the interest of the third party.
Yeah, Your Lordship, if it is posted on Monday, I'll.
Monday.
My
Yes,
lord,
Your
kindly
Lordship.
see the judgment of the apex court judgment, my lord.
I'll see on that day instead of wasting time 2 times.
Yes,
Yes, Monday, at the request of non-counsel the respondent, delete this matter from dismissal. Yes,
For
yes.
orders matter, serial number 3.
Yes,
Serial
memo
number
for
3.
acceptance of paper publication.
Ah.
In respect of R2 and R4, so memo is filed, memo is accepted, notice to so and so is self-sufficient. Yes, next, admit post for final hearing, call for the DCR. 4,
Serial number 4. Sri Harsha.
My lord.
DCF.
Needful done, my lord.
it is submitted, the needful is done, let's just matter of service of notice.
Serial
5,
number 5. RB Sadashivappa.
My lord, I am for the appellant in the connected matter, my lord, where you have challenged the liability and negligence and quantum of compensation.
representation on behalf of the appellant in MFA number 5218 of 2022, list this matter for dismissal. Give the date on 10th of September. Yes, 6.
For 6. Shantraj K.
My lord, I am for the respondent, I am ready for argument.
No representation for the appellant. Counsel for the respondent is present. List this matter for dismissal on 16th of September. Yes, 7.
7. Serial number 7.
What is this memo for withdrawal of the appeal? Take it.
Ah.
A memo is filed stating that the matter is settled out of the court. Hence, they want to withdraw the appeal. Accordingly, dismiss was withdrawn. Case
Serial
next.
number 8.
Maybe, let's notice to 3 and 4 may be dispensed with.
Do that.
Ah.
I give you memo.
No further adjournments on the day. The matter will be heard and necessary orders will be passed. A memo is filed seeking dispensation of notice to R3 on the ground that
R3 and R4,
R3 and 4
since no relief is granted to them.
as a relief, as per the order, the amount of compensation to be shared between respondent number 1 and 2. As such, the respondent number 3 and 4 are not necessary for deciding this appeal. Hence, notice to the 3 and 4 may be dispensed with. Accordingly, memo is taken on docket record. A notice 3 and 4 is dispensed with at the risk of appellate. Yes,
Delay of.
IA number 1 of 24 is filed to condone the delay of 60 days for the reason stated. Delay is condoned. Ready?
Not ready, man. 10th or 11th.
Listed on 18th finally, no further adjournments. Yes, 9.
Number 9.
Kind of tomorrow, my lord. File is
Why
not-
tomorrow? IA number 1 of 23.
Yes, my lord.
Till
File
now,
is-
no notice to the respondents. Give that what has happened on the last occasion.
I'm-
No representation on appellant side.
File is misplaced. Tomorrow I'll argue them.
No representation on 23-1. No representation on 4-1. No representation on 12-1.
Last chance. Tomorrow I'll be ready to.
And I'm telling you today itself, I'll dismiss both your IS. This is matter tomorrow.
Yes.
Cell number 10. Cell number 10.
Appear for the
K.
appellate, my lords.
You are for the claimant.
Dada BP.
You are for the claimant.
Please, my lords.
IA number 1 of 20 is filed to condone the delay of 105 days. The delay is condoned on the condition that he will not be entitled for interest for the said delayed period. Yes, ready? Who appears for the respondent?
Srimati Radha for KSRTC.
What is this matter about?
My lords, claimants appeal seeking for enhancement in a case of injury, my lords, personal injury. He has sustained fracture of
Presentation for the respondent, counsel for the appellant is present. Admit, post of final hearing, call for the DCR.
Cell number 11. Cell number 11. Rangegowda NR, appellant.
Same, then this delay is of 195 days, not entitled for interest. Admit, post of final hearing, call for the DCR. Yes,
Number 12.
this also 83 days delay, unknown. No conditions in this. Admit, post of final hearing, call for the DCR.
Cell for admission, cell number 13.
past forward, my lord. Rajiv said he will come.
Huh?
Pass forward.
Password. Who appears for the respondent?
Rajiv appears.
Gopal Krishnamurthy for Avan.
Respondent
ready?
number 1, kindly pass over.
Rajiv for appellate, my lord.
No, afternoon you are ready to argue. Yes, password.
Cell number 14. Ravishankar Shastri Ji for appellant. Harini Shivanand.
Kindly
I
view the
appear for the respondent.
both matter. I already appeared owner, and also I will file a claimant also. I file a retirement membership. Kindly weak account.
Very good.
By oversight.
Matter on 23rd at the request of an counsel for the appellant. Yes.
September. Cell number 15.
The
Antraj.
needful shall be done.
I appear for second respondent. Today I have received the color. Tomorrow I will.
No, but they have to serve notice on R2. You appear for R2.
R2.
Then counsel appearing for R2 submits, Mr. Shankar Reddy submits that. He has received vakalat today and will be filing during the course of the day. No representation for the appellant. This is matter on 24th. Yes, next.
Cell number final hearing, cell number 16. Ravishankar Shastri.
And for the fourth respondent in this case.
R2 in connected matter 8093.
Give that number.
80. It is linked to the 16.18092.
And for the insurance company connected matter.
8803.
No, their appeal is not listed according to
8093.
What is the number? Their number.
8093 of 2000.
8093 of 28.
It is already there. It is their appeal only.
It is.
What is that? You appear for whom?
I'm appearing for insurance company.
Your
There is no
Lordship-
liability against us in the court.
Where is he? Just so somebody was representing the.
Your Lordship, in this case, there are two insurance companies as two vehicles were involved. One is Oriental Insurance Company, for which my brother is appearing.
Shankar Reddy is appearing for.
For R2.
R2 Oriental Insurance Company. I'm for respond number 4 in MFA 835/2020. And in that 8093, they have not implemented me as one of the respondents, Your Lordship.
No representation for the appellant insurance, appellant claimant. List this matter on 25th of November.
Cell number 17.
Admit post of final hearing, call for the DCR.
My lord,
Then give a date. Admit final hearing matter, and then give a date. Yes.
my lord, in 17 I have not been served the copy in crop, my lord. And for the appellant in
No
871 of
No
2020.
representation in 17.1. Counts for the appellant is present. Submits that the probe is not served on the counter. This is matter on 11th of December.
Cell number 18.
Where is Mr.
Papi
Shastri?
Shastri.
What is this about? Oh, where is he then?
Sripa Shastri is not in station today.
Not in.
He's been to his native for a festival.
He submitted that there is no representation on behalf of the appellant. Counts for the respondent is present. This is matter on 24th September.
Please.
Cell number 19 urgent, 20 urgent. Cell number 19, Nagaraj Reddy, 19.
19 is also your matter. No, no. it is there.
20 and 21.
90 is not urgent.
19 is there.
19 is also the claim petition and dismissal.
Nagaraj Reddy.
No representation. This is matter for dismissal on 15th of September.
2021 urgent. Cell number 22.
I'm appealing for the respondent number 2, my lord.
Case of injury, my lords. Appeal is for enhancement, my lords.
Come to the table.
Please, my lords. Page number 23.
What are the injuries?
My lords, two fractures are there, my lords.
Right tibia, fibula.
Right side open tibia, fusula fracture.
Two fractures, another 10,000, another 5,000 we will increase. Pain and suffering.
My lords, here, my lords, what happened is, my lords, the loss of future income is.
That will come to the table. That's why I asked you to come to the table.
Please, my lords.
23.
Please, my lords.
So first pain and suffering, then medical expenses as it is.
Please, my lords.
89,917. Next, how many days?
He was admitted for 8 days, my lords. He was hospitalized.
Attendant, diet, nourish, transport. He was for 8 days.
8 days, my lords.
We'll grant 8,000.
My lords.
Then loss of income during laid up period.
Please, my lords. Notional income is, my lords, 8,500. My lords, if we.
Which year is the accident?
2014, my lords.
8,500.
8,500, my lords.
Loss of income during laid up period. Will take 3 months.
Yes, my lord. My lord, for that, in the para number 24, my lord, during the cross-examination PW2, Dr. Monappa Naik has admitted that he was not advised the petitioner for not to do work. The petitioner is completely recovered from the accidental injury. The petitioner finds it difficult to climb the step. That only they said, my lord. There's no, he was working in that period of accident.
Next.
The only slight difficulty in climbing the steps, my lord.
Then what did the doctor say? Did the doctor give any evidence with regard to disability?
My lords, he have given in chief examination, my lords, he have stated, my lords, 17% disability to the right lower limb, my lords.
Cross-examination, what did he say?
Cross-examination, my lords, he was suggested, he told, my lords.
What we do is, with that evidence, we'll grant some amount under loss of immunity.
My lords, what
your doctor says, everything
doctor
is
told,
fine.
my lords, I have not told him to work. That doesn't mean, my lords.
I have not told him to work.
Yeah, that means, my lords, he told, ನಾನು ಅವರಿಗೆ ಕೆಲಸ ಮಾಡಬಾರದು ಅಂತ ಹೇಳಿಲ್ಲ. That means, my lords, he has not suggested him to work.
He was working, my lord, at the time of accident.
There is no
After the
evidence to
accident,
show,
he
my
was
lords, he
working.
was working, my lords. Previously, he
that
was working as a waiter.
Whether the disability aspect, whether the doctor said that there is disability or not. Working, you forget.
Yes, ma'am.
Doctor has said there is disability.
There was the disability, but he said that only slight difficulty in climbing the steps. There is no.
But then, disability how much to the limb?
It is, my lord,
He's not examined. He's not
17
mentioned in the. He's not mentioned any proper disability percentage, my lord.
In cross-examination, what he
Will you tell the court what is the disability according to him?
According to the doctor, my lords, in his chief examination, my lords, he have stated 17% disability to the right lower limb. That is what he have stated, my lords, in the chief examination, my lords.
Comes to 5%.
5%.
5% to
Please,
the
my
court.
lords, 5%.
What is the income? 8,500.
Yes, ma'am.
8,500.
What is the multiplier?
16.
Loss of amenities will grant 10,000. 10,000.
Yes, ma'am.
It comes to 2,85,017 against 1,51,917.
Please.
Please come. Agreed with the award passed in MVC number 597 of 2015, dated 10th January 2022, whereby the court had granted 1,51,917. The claimant is before this court. Land counsel appearing for the appellant claimant submits that the claimant had sustained 2 grievous injuries, but the court had granted only an amount of rupees 55,000 towards pain and suffering. Under the head of loss of income during the later period, court had granted only 1,600. Under the special diet and nourishment, attendant and conveyance charges, the amount that is granted by the tribunal is not a just and reasonable compensation. Further, it is submitted that the doctor has deposed that he has sustained 17% disability to the limb. Even on that count also, no amount is awarded. It is submitted that the amount on all respects needs to be enhanced. Learned counsel appearing for the respondent submits that even after the accident, the claimant was working and the injuries that are sustained, the disability that is sustained is not coming in the way of the his employment and income, and the court had rightly not considered. And on all aspects, the amount of compensation that is awarded by the tribunal is just and reasonable. Next, having heard the counsels on either side, Parisa Mitchell non-record, considering the fact that he has sustained 2 injuries, 2 fractures, this court is granting 60,000 under pain and suffering medical expenses as awarded by the court, 89,917, and this court is not interfering. Considering 8 days of hospitalization under attendant diet and nourishment, 8,000. Coming to the loss of income during the later period, considering the fracture injuries, this court is granting, considering the notional income at 8,500 for 3 months, this court is granting 25,500. Coming to the loss of future income, there is no dispute about the fact that the doctor has opined that he's considering he has sustained 17% disability to the limb. Hence, 1/3 of it is 5%, and this court is considering the disability at 5%. 8,500 into 12 into 16 into 5 by 100 is 81,600. Under the head of loss of amenities, that the doctor has stated that there is difficulty in claiming the steps. This court is granting 10,000. In the light of the law laid down in so legal expenses 10,000. Altogether, the claimant is entitled for an amount of rupees 2,85,017. Accordingly, appeal is partly allowed, enhancing the compensation from 1,51,917 to 2,85,017. Accordingly, the appeal is partly allowed. The enhanced amount shall carry 6%. Yes, next.
24.
Much obliged, ma'am.
24. Bill number 24.
I appear for appellant, madam. Claimants appear for enhancement, madam. Case of injury, madam, only 2 grounds, madam. 4 fracture is there, madam.
Come to
Madam, one submission, please.
23, they are not informed me regarding the adjournment.
When?
23, is 23, adjourned, but they are not informed. And let tomorrow they argue the matter.
When is it adjourned? When is it adjourned? I understand. To which date?
18.
This is matter instead of, is the matter on 23rd September. Yes, 24. The table.
Sustain my lord, fracture my lord, page number 10 and para number.
Already pain and suffering and loss of income during later period.
Yes.
Put together it is granted.
Yes, my lord. My lord,
And the pain
Lord,
and suffering.
Lord, according to me, I think he's been overcompensated.
No, we'll just calculate.
I think he's been overcompensated is my personal opinion.
See.
Yes, my lord. Your lordship may kindly turn to internal page 10 of the judgment, issue number 2.
No, I'm looking at the table. Pain and suffering, how many?
No, pain and suffering, your
4
lordship.
injuries.
Huh?
4 injuries, my lord.
4 fractures.
Yes, my lord. Suffered fracture medial malleolus of left leg, fracture spine of
So
scapula right.
independently we'll see pain and suffering for 440.
Lord, can I just take your lordship to the page 10, my lord? Page 10 of the internal page 10 of the judgment. Issue number 2. Just one paragraph I'll read. Exhibit P7 wound certificate revealed that the injury caused to the petitioner was such as left medial malleolus fracture. According to Exhibit P7, the injury is grievous in nature. The discharge summary, which are at Exhibit P8 and P18, the petitioner had suffered fracture medial malleolus of left leg, fracture spine of scapula right, undisplaced left actibular fracture, and fracture right proximal phalanx
So
of
four
little finger.
fractures.
4 fracture.
Four fractures.
So pain and suffering will valid 80,000.
Pain and suffering, Lord, 92,000 rupees, I believe.
That is including loss of income.
Loss of laid off period.
So we will take it pain and suffering 80,000. And he was in hospital for 20 days.
20 days, my lord.
So attendant, nourishment and all will grant 20,000.
All right.
Then loss of income during later period.
That's been compared.
That is added in pain and suffering.
Yes. That's another 42,000 rupees.
The income during later period.
42,000 because he has not proved his avocation.
What is the notional income?
Not 14,000.
14,000, my lord.
14,500 with 4 injuries. We'll take it 4 months. 14,500 into 4.
58.
58,000.
Pain and suffering, my lord.
Pain and suffering 80,000 and all. Then attendant extra medical expenses as it is.
Attendant charges are also is quite reasonable. Attendant charges 25,000.
So they have awarded 25. I made it 20.
Yes.
We'll make it 25 then. Court has already awarded medical expenses
As it is.
as it is 55,844. Then now the loss of future income.
Loss of future income.
What is the enhancement you are seeking?
My lord, the doctor stated that my lord, disability 39% left lower limb and whole body 13%, my lord. The criminal is considered 13%.
No. What is that? 30?
13%.
39% left lower limb and 13%.
13 is correct.
My lord, criminal is taken only 10%, my lord.
Lord, your lordship may kindly see, he's the doctor. Can I just read the relevant portion of that portion? There, the court very clearly holds, page 11, my lord, page 10, the last paragraph. According to the petitioner, because of the injuries, he suffered permanent disablement and lost earning capacity. In order to prove the disability, he examined an orthopedic surgeon, Dr. Nagaraj BN, as PW2. The doctor has opined that the petitioner suffered.
Where are you reading?
Internal page 11, my lord, ink page 17.
According to the petitioner.
Yes.
Suffered permanent disability of
That's
the
right,
left lower
that's
limb.
right, yeah. Then the next page, my lord, next page. Permanent disability comes to 39%, to the whole body 13%. His evidence clear that he is not the treated doctor. I mean, it's wrong English, treated doctor.
No, but the thing is, how the court says 13% is not correct. I'll take 10%. There should be some basis for that.
No, so his evidence, so and so.
No, if the court,
And,
no, doctor, the court, what is the finding of the court? It is not affecting his perk
Yes,
allocation.
yes.
If that is the case, why should you take 10% also?
I leave it to the, that's exactly what my argument is.
No, but you are not preferred any appeal.
I've not preferred any appeal, but
What I'm saying is, when you're, what is the basis for you not to consider the evidence of the
no,
doctor?
that's a reason, Lord.
That reasoning is
That,
not
that
correct. That's what I'm saying.
13%, your lordship, can you read further? Implants were, implants were removed and the petitioner is not taking any treatment account of the doctor. In cross-examination, the doctor admits the petitioner can do his managing work, whatever it is. Hence, the disability opened by the doctor found the petitioner does not affect the evocation of the petition. However, having regard to the nature of injuries, the fracture is united well. There, he says there's no problem for him to carry on with his avocation. I don't know why.
But cross-examination clearly admitted, my lord. I was not working
Multiplier
as
and
an
all
agent.
correct?
Multiplier is correct.
Yes, correct, my lord.
We'll take 13%. It comes to 3,61,920. Then loss of amenities, how much is awarded?
Loss of 80,000, your lordship order.
We'll make it 20,000. Legal expenses. 10,000.
Medical expenses 55,844.
Yes.
Then attendance charges, your lordship made it 20,000, I think.
No, because we will not reduce that. I made it again 25,000.
Good. And then loss of future amenities and happiness, 50,000 rupees. That's.
What can it be? What is the special reason?
No, that's exactly what I'm trying to say. Everything is normal. He's back to normal.
Amenities 50,000 is awarded, my lord.
That is precisely what my argument is.
No, come to that.
My lord, pain and suffering, 92,000.
If 50,000, that's what I'm asking. For a disability of 13%, loss of future amenities and happiness, 50,000.
Again, it's a duplication. That's the reason I said I don't think this appeal requires any.
Maybe reduce, my lord. Only.
If we reduce, no, we can grant only for the loss of amenities, we'll grant 20,000.
Please.
So there would be difference of 30,000 in that. Yes.
Please.
Lord, can I just I always canvass this one particular point. Lordship, I can see when loss of earning during later period, that is for the entire, from the time he is hospitalized, whatever. And then how can there be loss of earning also, my lord? Don't you think it amounts to duplication?
There are two aspects. We are talking about loss of income during the later period.
That's right.
Because you're talking about the loss of future earning.
No, that's what I'm saying. See, sometimes what happens is loss of earning during the later period and also future loss of earning. So that means that.
It's only for months, 3 months.
Anyway, doesn't matter.
So now it is coming to 6,40,764 in spite of reducing that. Please come. Agreed with the award passed on embassy number 108.
My lord, what about a lot of amenities, my lord, future amenities?
Only 20,000 is granted. Okay. Agreed with the award passed on embassy number 1282 of 2019. Dated 8th April 2022. Whereby the court had granted 4,91,644 as compensation. The claimant is before this court seeking enhancement of the compensation. The claim petition is filed seeking compensation of an amount of rupees 15 lakhs for the injury sustained by the claimant. In the accident, the claimant had sustained 4 fractures and he was in hospital for 20 days. The tribunal had granted the compensation as per the table given below. Extract the table at paragraph number 13. Then counsel appearing for the petitioner submits that the court under the head of pain and suffering and loss of income had granted given an amount of rupees 92,000, which is on the lower side. Further, it is submitted that when the doctor has opined that his disability is 30%, to the whole body,
39%
39% to the
left
whole
lower
body.
limb, 13% whole body.
13% to the, 39% to the limb, and 39, 13% to the whole body. Court without any basis had taken 10% as the disability. Further, the court had taken 14,000 instead of 14,500, the notional income.
Allah, 2019, my lord, 14,000.
14,000, it's not
2019
14,000, 14. It is 14,000.
The difference. I have taken it as 14,500.
No, that's, it's only 14,000.
1 minute.
Or 14,000 into.
For that
into
year,
13%.
there's only 14, it's 14,000.
3,49,440.
14,000 into 4.
10%.
Comes to 50. You said 58,000.
Yes.
That is 56,000 if it is 14,000. 14,500, it is 58,000. Then 14,000.
40,000 to 10% into 12 into 16.
Yes, 14,000. It comes to 3,49,440. Now, basing on this, we have to count now. Plus 30. Plus. It's coming to now 5,96,284. This point, 14,000 and all that you delete. It is submitted that the compensation that is awarded by the court is not a just and reasonable compensation. Land counsel appearing for the insurance company submits that as the injuries are not coming in the way of the claimant for his future earning, court had rightly considered only 10%. I had rightly considered 10%. Further, on all counts, the amount that is granted by the tribunal is on the higher side. When it comes to loss of future amenities and happiness, when the disability is 10%, court had granted 50,000, that is without any basis. It is submitted that no interference is called for with a well-considered order passed by the tribunal. Next part, having heard the counsels on either side, there is a material on record. Considering the 4 fracture injuries he had sustained, under the head of pain and suffering, this court is granting 80,000. Considering the hospitalization, the tribunal had granted towards attendant and transport 25,000, and this court is not interfering. Coming to the loss of income during the later period, 14,000 into 4, 56,000. Medical expenses, court had granted 55,844. No interference is called for. Then coming to the loss of future income, when the doctor had opined that the disability to the whole body, to the limb is 39, whole body is 13, the reasoning that is given by the court for taking the disability at 10% is not satisfactory. In the light of the evidence of the doctor, this court is inclined to take 13% as a disability. 14,000 into 12 into 16 into 13 by 100 is 3,49,440. Considering the disability, this court is granting loss of amenities at 20,000. In the light of the law laid down in so and so towards legal expenses 10,000. Altogether, the claimant is entitled for an amount of rupees 5,96,284. Accordingly, the appeal of the claimant is allowed by enhancing the compensation from 4,91,644 to 5,96,284. Accordingly, the appeal is partly allowed, and the enhanced amount shall carry 6% interest.
Till number 25, F.S. Dabali of appellant, Madhukar M. Deshpande.
Appeal by corporation on case of death murder. Appeal has been filed challenging the finding of the tribunal on the point of negligence murder as well as the quantum.
Where is the other side? Counsel for the appellant is present, no representation for the respondent. This is the matter on 11th November.
Sorry, Lord. I may be directed to file wakalat within a particular.
Not fine. Within 1 week from today, the land counsel for the respondent insurance company shall file the wakalat. Yes.
Cell number 26.
25.
No, they are not there. Respondents are not there.
No.
I gave a long date. You want a short date?
Short date.
11.
Huh?
Yes, ma'am.
This is the matter on 16th. The counsel for the appellant is present. No representation for the respondent. List this matter on 16th. Even on the day, if the respondent is not there, the matter will be heard and orders will be passed. Yes, next.
Cell number 26.
Yes.
Okay, Prasanna Shetty.
Kindly pass out the matter, my lords.
Password.
Submit my
Yes.
arguments.
27.
27. Cell number 27.
Harish Annar.
Ashok N. Patil. Azadu.
That is
Muralidhara
also-
N for appellant.
No representation on behalf of both the council. Yeah, list this matter on 11th of November.
List number 3. For orders matter, sale number 1. Prasanna VR. Acceptance of notice issue.
Yes, memo along with the paper publication has been
Service.
furnished.
Acceptance of notice, yes. Notice 2. No, only one respondent.
Yes, ma'am. No, 3 responses.
Memo is filed seeking.
3,
acceptance
sorry,
of
madam.
notice.
Only one
Two
respondent.
respondents, huh?
One respondent and petitioner are 3 members. One respondent.
One-
Only one respondent.
That's what I asked. Notice to,
Four
the
respondents.
memo is filed seeking the acceptance of notice to respondent number 1. Same, it is accept, notice to so and so is held sufficient. List this matter, teacher is already there. List this matter on 25th of September.
Great.
Yes,
Sale number 2.
compromise petition.
Yes, Millard, the last,
Compromise
the MC matter was
I remember that.
set down for 22nd. Millard, on that day, Millard, it was urgent, again urgent, that is the reason.
What date?
Millard, after 10 days, Millard, your lordship. So,
No,
10
they must have given a date.
Yes,
What is the date?
Millard, I think second week of September.
Court, how will the court? will
Exactly,
give-
Millard, I could not contact because party is not lifting the phone, that is the
Second
reason.
week of?
Second week of Millard, September.
List the matter on 18th
18.
at the request of learned counsel for the petitioner.
Sale number 3. Sale number 3. Rajesh A. for petitioner. N. Kumar.
Where is Rajesh?
Is this one? Yes, list number 3. List number 3. Figure number 3. Oh, sorry. Sorry.
Yes. No representation. No representation on behalf of the petitioner. And petitioners in 3 and 3.1 list these matters for dismissal on 19th of September.
Sale
Yes.
number hearing on interlocutory application. Sale number 4.
My lordship.
Manmohan.
Before my lordship takes up the matter, I'm filing an IA, serving copy. I'm filing an IA since if the order sheet is perused, my lordship, on 13 December 2023, this honorable court was pleased to grant an interim order for condition of stay, asking the petitioner to pay 50%.
Kindly pass over, we'll be arguing the matter.
Also,
Sale number 5.
Much obliged.
Sale number 5.
For the respondent.
Is Sri Hari?
Sorry, one second.
The petitioner, madam, taking a short date, madam.
till Karnataka release.
No, it's more than 300 days. Difficulty is she has filed multiple petitions for multiple courts in the during that period only, including before this High Court. That's why the reasons are not. This one. I have filed detailed objection along with.
Yes.
But since they filed objections, we'll hear, madam, but senior's not there, madam. So short date will be given.
Why short date?
Not received
What
the
happened to the
objections.
last, what happened on the last occasion? Because you're not understanding, every time matters adjourning like, IA number 1 of 23 is filed to condone the delay, respondent seeks time. When did you file your objection?
No, it's more than a week before.
It is submitted by the learned counsel the respondent that a week back, he has filed his objections to the
No, no,
IA.
1 month before. 28.
The back.
Please, 28.
Serve the same on the counsel appearing for the petitioner. List this matter on 10th for the time.
Obliged.
Sale number 6 for admission. Cell number 6, Harish TS.
Filing objection.
Six, not objection. I am the proxy counsel in this case.
Why should they at all be filed here? Why not in the registry?
I tried to contact the petitioner, your lordship.
The counsel for the respondent has served the objections on the counsel for the petitioner and submits that he'll be filing the same in the due course of the day. Don't give it here. File it during the course of the day. List this matter on 13th. Yes.
Cell number 7, Ravindranath K, for petitioner.
No representation for dismissal on 18th.
Cell number 8, Sampath A.
For the respondent, my lord.
Ganesh Bhatt.
Petitioner, the petitioner husband, my lord, your representative has not contested the matter. Lord, I deposited 50% of the amount as 5 lakhs and also paying the amount. Well, it could be remanded. I request, I will contest.
My lord, in MC petition filed for restitution of conjugal rights, he has entered appearance, not filed any objections. It came to be allowed. And in the criminal proceedings which for maintenance, he has entered appearance, not contested, not filed any assets and liabilities. And the trial court has rightly, the claim was for 26,000 and odd, 10,000 has been rightly awarded. And he has not filed objections.
What happened to the MC which is filed for
Restitution has been ordered.
He has not
He has not filed, challenged it. He has not taken her back. And 26,000 odd has been claimed. And he has properties at Hoskote as well as properties at Channapatna, Ramnagara, as well as his in Tamil Nadu. He has not filed any statement of objections in both the matters, not chosen to file assets and liabilities. Trial court has rejected my claim for 26,000 on the ground that I have not produced the document relating to his property. And I have produced the medical record to show that I have undergone surgery for back pain, and I have a problem of.
What is the salary?
His salary was 41,000.
40?
41,000.
How much the court had given?
Court has awarded 10,000.
Then what is the difficulty?
No, my lord, sir, regarding the salary, my lord, it's a disputed fact. My lord, he said he's a retired BSNL peon, my lord.
I have produced the salary slip.
My lord, he has not produced salary slip, my lord, I guess.
Exhibit P2.
Regarding salary slip, I will check it.
Simple instruction. What is the salary?
Lord, sir, I will just check the salary slip because, my lord,
41,000. No question of interfering with that.
that's an equitable amount.
At the request of turn comes for the petitioner. Finally, list the matter on 11 September.
Please.
To get specific instructions.
Instruction on the salary.
What is the salary of the
Please.
petitioner? Yes.
Finally, reading cell number 9, Abubakar Shafiq.
Serial number 9, I appear for the petitioner husband, my lord.
Where is the respondent?
This case, my lord.
Pass over. Counsel for the petitioner. Respondent is not there. Pass over.
Pass over, my lord. Pass over. Afternoon, I have some little.
List this matter on 14th of November.
Obliging.
No representation for the respondent. Counsel for the petition is present. Yes, 10.
10, Venkatesh Somareddy.
Minutes, Honor. Proxy counsel for the petitioner, my lord, he is out of station. Kindly short adjourn. Minutes.
At request, list the matter on 27th October. Yes. Completed. Anybody is ready with the passwords?
Passover matters.
My lord, your lordship had asked us to file a memo regarding hand summons being issued. I filed the memo and the concerned advocate's name is.
There is that number?
List 1, serial number 8.
8, my lord.
Serial number?
8, my lord.
They have
8
to
or
write
18?
8.
8. Take that file. 8. As per the orders passed by this court, it is submitted that the hand summons are taken and they served it on the counsel appearing for the respondent, that is Chidananda
Kedilaya.
Laya.
Kedilaya.
Laya.
Katie Laya.
And a memo is filed to that effect. Print the name of the counsel and notice to the respondent is held sufficient.
Any date may be granted.
List the matter on 16th September.
Grateful, ma'am.
Yes, next. Any other passover?
Passover matters.
Lordship, my matter can be taken up. I can make.
It should be there. Other side should be there. Yes, done. This other lists are also over. No, in the next list. Done. How many passwords are there?
5 to 6.
5 to 6. Done. Where is it?
The memo Capilla, madam. Memo filed in court Capilla. Date. Inter matter. ಯಾವಾಗದಲ್ಲಿ ನೀವು ಕೇಳಿದ್ರ ಅಲ್ಲ ಇದ್ರೆ ಆಕ್ಚುಲಿ ಅಲ್ಲ ಯು ಹ್ಯಾವ್ ಟು ಇಟ್ ಇಸ್ ಯುವರ್ ಡ್ಯೂಟಿ ಟು ಸಬ್ಮಿಟ್ ಟು ದ ಕೋರ್ಟ್ ಅಲ್ವಾ ಲಾಸ್ಟ್ ಅಕೇಶನ್ ಅಲ್ಲಿ ನೋಡಿ
Court officer? Court officer?
ಹೇಳಿ ಸರ್.
Sitting close ಆಯ್ತಾ ಮಧ್ಯಾಹ್ನ ಇಲ್ವಾ?
ಸರ್ ಮಧ್ಯಾಹ್ನ ಇದೆ.
ಹೌದಾ? ಇದು fourth list ಏನಾಯ್ತು ಮೇಡಮ್?
ಫೋರ್ತ್ ಲಿಸ್ಟ್ ಎಲ್ಲ ರೆಫರ್ ಟು ಲೋಕ್ ಅದಾಲತ್ ಸರ್, ಅದು ರೆಫರಿಂಗ್ ಟು ಲೋಕ್ ಅದಾಲತ್ ಮ್ಯಾಟರ್ಸ್ ಅದು.
Okay.
Court officer?
Thank you, madam.
Court officer? Court officer?
ಸರ್ ಹೇಳಿ.
ಅದೇ ಲಿಸ್ಟ್ 3 ಸೀರಿಯಲ್ ನಂಬರ್ 9 ಯಾವ ಡೇಟ್ ಕೊಟ್ಟದವರು?
ಇದೆಯಾ? ಆಮೇಲೆ ಲಿಸ್ಟ್ 3
ಲಿಸ್ಟ್ 3 ಸೀರಿಯಲ್ ನಂಬರ್ 9
ಒಂದೇ ಒಂದು 4 ಅಷ್ಟೇ, ಯಾವ್ದಿಲ್ಲ. ಅಷ್ಟೇನಾ? ಇದೆಲ್ಲ
ಹೇಳಿ ಸರ್, ಏನ್ ಬೇಕು ಹೇಳಿ.
ಲಿಸ್ಟ್ 3 ಸೀರಿಯಲ್ ನಂಬರ್ 9 ಯಾವ್ದು ಡೇಟ್ ಕೊಟ್ಟದ್ದು ಅಂತ ಹೇಳಿ.
ಯಾವುದು ಸರ್?
ಲಿಸ್ಟ್ 3 ಸೀರಿಯಲ್ ನಂಬರ್ 9.
That is on 14th November, sir.
14th November ಸೆಪ್ಟೆಂಬರ್ ಅಂತ ಅನ್ಸಿದೆ.
November.
ಆಯ್ತು ಮೇಡಮ್.
All the parties. I wanted it to send it.
Pass over matters, list number 1, serial number 2,
Here for the petition.
Arun Govindraj, Sai Guru, Sarkera.
So I have filed a list of objections to the documents produced by the respondent. None of the documents as sought for in the application, or at least not the
What to
complete.
do is, I
Yes.
will address it in the main case itself, all these issues.
Very well.
So please tell the court, WP number 16445 is questioning.
This is the wrong decision.
This visitation.
This is the one to give, this is the one to the court.
Then 2.1,
But both the other petitions, one by the husband and other by the wife, are challenging an order of maintenance. I think that we have consensus between us that the order was passed during the pendency of these proceedings where your lordships had made some interim arrangement, and that was brought to the notice of the family court. So both were not heard really before that order was passed on the. So far that aspect is concerned, I think on the maintenance, we will have to go back before the family.
No, Lord, we've spent so much time here. Lord, we had pointed out that your lordship have recorded in the last order to put a quietus. Your lordship will consider, Lord, the maintenance aspect. Lord, I've made a small list of dates just to recapitulate, Lord, the facts. Lord.
So far as the maintenance is concerned, my submission is this. The family court allows my application under
so no,
section.
first of all, what is the difficulty with two visitation? Visitation.
Visitation, this Lord is taken care of because 15 days.
You have nothing. We'll dispose it off first.
Very well.
Yes.
First one, WP 16445. This is the one.
It's okay.
When is that order passed by this court?
Lord,
With regard
the
to
lordship's
visitation.
order.
The last orders.
Order sheets are bigger than the file.
Lord, I'm grateful to the court. If your lordship had not taken the interest, Lord, at least the parties, they're there at loggerheads. So far as husband and wife relationship is concerned, as parents, they have an understanding. And this was, Lord, when I presented the petition before this court, the father had not seen the children for 1.5 years.
Lord, 4/11/2024 order.
4/11/2020.
So let us not be disposed, let us not be penalized.
With regard to the visitation,
Look, now what we had agreed is that 15 days the children will live with
where
the
is that?
father.
By which order?
That order, I'm just looking at. October. This is 2025.
Is it 1812?
1812, Lord, is. Lord, 411,
Or 12/3?
paragraph 2, my lord.
No, 12/3. This is where 15 days thing has come.
On 4/11/2024, the submission by the learned senior counsel has been recorded at paragraph 2.
4/11.
Today, when the matter came up, learned counsel appearing for the petitioner and learned senior counsel appearing for the respondent submit that visitation is going on well and the mother is ready to give custody for 15 days.
Paragraph number 2.
Paragraph number 2 on 4/11.
Custody for 15 days, but the
Yes,
father is
and-
only taking the children.
Yes. Thereafter, on 12/3, my lord passed the order, 15
Yes,
days.
12/3.
12/3.
Let the judge meet one last time, then let us finalize it.
So this arrangement of, with the arrangement of 15 and 15 days,
Lord, broadly, yes, my lord, we don't have a problem. But I'm just being instructed that the children are facing some issues. If your lordship can give us some time to bring the children before your lordship, my lord.
no, She
No,
has-
your lordship have met the children.
I met the children.
Yes.
She also, but what is her, she can tell the court precisely
Yes,
what are all the problems.
Yes. What is the problem?
And they require any riders, we can pass that order.
Yes, my lord.
My lord, I've been instructed that he's still displaying anger with the kids, and also the psychiatric treatment, like the psychology
They're not
session,
going.
they're not being taken as such.
Please ask him.
And also the kids are expressing certain hesitation. They are, that's what I've been instructed, that they do not want to stay for the complete 15 days. They want to have it revised as they're not comfortable for the complete stretch of 15 days is what I've been instructed.
Not so far as the
So-
counts.
How about it works like a week and a week, alternate, like,
Alternate
1 week with the
weeks.
father, 1 week with the mother? Is it is it difficult with the school, this thing?
Yes.
No, the school,
Dropping
the,
it
no,
won't be.
My lord, difficulties are faced logistically as well with respect to schools. 15 days was ideal. But what happens is 1 week, since they're residing at different addresses, the bus aspect comes into an issue.
What I'm saying.
Yes, my lord. So recently, a lot of issues have cropped up with respect to bus because the school is now being dragged into all these issues wherein order is here, order is in there, this is the order, and the school is being troubled. So apart from that, keeping all of these logistical issues aside, my lord, the kids are expressing some discomfort is what she said.
Understood.
So the request is, my lord may interact with the children one last time and then accordingly an order may be passed.
But that, I think enough interactions have happened. Children are for the last almost 1 year.
At this point of time, no, they will, because we can understand what they will come out with without even meeting them. But still, whatever it is, we just can't stop the father. And anyhow, this 15 days thing is going on. If the mother says this is how the children will be comfortable, we'll include it in the order.
your lordships may make it subject to any orders which can be passed, my lord, either by the family court or the lord.
So what happens is now again another round of litigation.
Reopening.
Client will start, everything will start again. That's the whole problem. So we shouldn't keep the doors too open. So on a limited grounds, I will try to, if this,
So we will submit by the next date a fresh co-parenting plan involving all aspects, use vacations and everything, and we can find out. Is it then?
Look, what is being said is that we'll file one affidavit or something in writing by not very far, my lord, just about a week from now, and then your lordships may pass the final order. Just putting across the issues that are coming across, because I frankly, my lord, because this 15 days thing was already running, I did not take any instruction on this, my lord. I was only concentrating on the maintenance part.
as far as taking them to the therapy sessions and all, we can say that the
Yes.
complaints has to be there.
Yes.
And whatever problem she says, no, all other arrangements will now affect, that she has to understand.
Correct.
If she says father can't meet, he says.
No, no,
I
she's
have
not saying that at
whatever,
all.
that 15 days, no, he has got used to that now. Now he will say that my pocket is not permitting for the other things. So these are all interdependent. She
Yes.
has to understand that.
Yes, yes. Lord, I'll
Tell her, I will dispose of all that and this together.
Yes.
Not on a.
But my lord, I am only requesting because she is not getting any maintenance. Lord, she is now running out of the money that was with her, my lord. I can place the documents before your lordship, my lord, to
we
show
will
that.
definitely consider, you please advise her also.
Yes, yes, my lord,
But
certainly.
It is only like we have to balance both the aspects.
Certainly, my lord, certainly.
So I will dispose of both. You come up with whatever you want, and that day only, same day, both of them will be disposed of.
Yes, my lord. But please hear us on maintenance because she is not getting any maintenance. My lord, what is being paid is 75,000 for the children, and she is getting nothing.
That's what I'm trying to say is, I will hear you on the maintenance aspect.
Yes, my lord.
It is subject to what is that she's going to say on the visitation aspect.
Lord, broadly, I can assure this court, my lord, there will
Has
not
to
be.
there some.
Lord, broadly, I can assure this court that 15-day thing will not be, Lord, affected. But some, my lord, as your lordship said, some riders will have to be put in.
Whatever rider she says.
Yes.
Like father has to do this in the interest of the children, we will.
Yes, yes.
But the bottom line is
No,
has to be
that
there.
will not.
I have one last request. 29/4/2025, your lordship directed the mother to hand over either Aadhaar card copies or some, because if the father has to travel anywhere with the children, Lord, there are no identity cards with him. Copies. There's a direction by this court to
But
hand
there was
over.
an order for Milord for permitting him to take the children on a holiday. He did not take them, Milord.
But
All this
ID
is
cards.
Aadhaar card. What is the problem?
There's a difficulty for that.
Lord,
She can't be.
Lord, I am told that, Lord, they were both born outside India. They don't have Aadhaar cards. Some other kind of, Lord, identification are there that we have already given.
School ID is what is given, my lord.
It's sufficient to travel.
I'm sorry.
Unless,
My lord, may I make this request? Sorry, one submission with my learned friend's permission. My lord, foreign nationals, the son is a foreign national.
Both.
But for him to stay,
both.
He requires OCI, overseas citizenship of India, or he requires a residential permit. To our knowledge, my lord, both those documents are not there with the son. In fact, he's living here without any authority of law. We've been asking for either making that OCI card for the son or asking for a copy if she has got it. To date, my lord, there's radio silence from them.
Lord, the
Let
concern,
the court, my lord, what the son has. Whether he's got OCI or not, whether he's got residential permit to stay in India or not.
It's not there. He knows it very well.
We have no document.
Lord, the thing is, Lord,
Both of them are
no,
letting
the
the
concern
children
is,
go for
Lord, the
illegal
concern
stay
is,
in
the
India.
concern is that he may leave India with the children, my lord. That is why we have flatly said, my lord, that the passport will not be handed over. Now he can, my lord, with the OCI card, Lord, he can, my lord, apply for a fresh thing. So that is why it is not given, my lord.
I've done affidavit of undertaking. 15 days custody.
No undertaking.
This is-
Lord,
Lord,
let the children be where they are. Lord, they are meeting the father, they are meeting the mother. Lord, let it happen for some time, Lord. Afterwards, if they want these documents, Lord, they can apply to the court.
I'm the father, my lord. I don't even have
Lord, there is a
identification documents
concern.
of my children.
There is a concern.
But Lord, I can have the same concern that the mother will fly away from the country without with the children. I'm only asking for copies of documents, not the originals. I'm asking for photocopies.
Lord, 2022, from 2022 October, she is not left anywhere. She is here only. We can show that, you know, you've been,
With the copies of the documents, what he can.
copies we can give.
Copies
We can give
only.
one more.
He was
sir.
asking
We can give
copies.
one more.
That's what he's
Ah,
asking.
that's all I'm
copies.
saying.
Give them the copy.
Yes, yes.
What is that overseas?
Passport copies, OCIs and Aadhaar. Lord, Aadhaar, irrespective of nationality, Aadhaar is given to any resident in India. It doesn't depend on nationality. There are any number of foreign nationals who have OCI cards with Aadhaar cards in India.
Necessary documentation, Lord, for inland travel will be given.
Documents.
Passport copies, OCI and Aadhaar. These are the three documents.
No, my lord.
If you want photocopies.
Please don't specify.
The passport is required.
Please don't
Photocopy,
specify,
my lord.
my lord.
Photocopy.
Not required because
Very
you
OCI, very well.
take them.
Very well.
So for other things like Aadhaar card and the
Aadhaar card, my lord, even if they don't have, we'll apply and get it in.
OCI.
Yes.
OCI also. Because son is a foreign national. We don't know.
Lord, I don't have instruction on OCI, my lord. Frankly, let this discussion happen next week.
No. Huh? You will give
Not whatever OCI is required.
OCA and Aadhaar
Do you
card.
have OCI?
Then not required.
Lord,
Lord, I have not applied my mind to this, my lord. Frankly, I'm telling you.
Necessary document necessary.
She says it's not required, Mr.
Lord,
Arvind.
Section 7 of the Citizenship Act. Lord, I'm personally aware of this because my own family, we have people, minors who have OCI.
Kudi, Nangan Kudi, I'll apply my mind to this and come back.
It's mandatory. Section 7 of the Citizenship Act. It is mandatory, my lord, for anyone to stay who stays in the country to have it. Either this or a residential permit.
Because
This
it's
is a OCI card holder, my lord.
No, it's
It refers to OCI card holder to apply. Lord, I apply my mind. I've not applied.
whatever it is, let the children be, their stay should be a legal stay.
Correct.
That should be taken.
That we will
care of by
ensure,
both
that
of
will
them.
ensure. We'll ensure that.
That copy has to be given to us.
Okay, once we ensure, we'll give it.
Which means
But if it is not applied, then we'll have to apply. It can't come out of the air.
No, otherwise, under the Foreigners Act, it's going to be a violation.
Give that. On the last occasion when the matter came up, this court has passed an order directing the mother to give the copy of the Aadhaar card. It was the Aadhaar card,
29/4/2025.
29.
4/2025, your lordship's order.
Get that. So and so, as passed the following order, when the counsel for the petition submit, the petitioner husband submits that the documents are not given. It is submitted that the child is a foreign national, the boy is a foreign national and he needs to
Lord,
have
both, my lord.
both the children are foreign nationals.
Son, only son is foreign.
No, child was also, daughter was also born in Switzerland.
Daughter is Indian passport.
The boy is a foreign national and he needs to have a overseas citizen of India card. It is submitted that without the same, the stay of the child in India becomes illegal and mother has not, he is not aware whether such a card is obtained or not. It is submitted that irrespective of the nationality, as they have been staying in India, they'll be getting the Aadhaar card. That is also not furnished. Then senior counsel submits that that he has no specific instructions in this regard, but he will instruct the respondent as far as the if Aadhaar card or the overseas citizen card is not there, she will apply and a copy of it.
Lord, what I'm told is that the child has 10 years visa, my lord.
At least that copy may be furnished.
Yeah, we'll give that. Obviously, the father would have taken it when they came to India, but then I'll give it, my lord.
On that, then I'll not record all this.
Yes,
With regard to Aadhaar and all.
Yes, ma'am.
They said that it is submitted that he's having a visa for 10 years and the copy of the same would be given to the father. Next, with regard to the visitation, it is submitted that the mother has certain concerns and she'll file an affidavit in that regard.
Yes.
And thereafter the court can pass appropriate orders. With regard to the maintenance, that is the two writ petitions that are pending, senior counsel submits that she's finding it difficult to take care of the children and the matter has to be heard. Then counsel appearing for the respondent further submits that in spite of an order passed by the court, certain documents are not given and he has already filed his objections to the same and also stated what are all the documents that are not given as per the order of this court. The list is matter on 10th.
Very well. 10th and 11th only I have a problem. Please, 11th is what?
15th?
11th is what?
15th?
Yes, ma'am.
16th, 15th, I'm not mistaken. 16th.
16th.
It's matter on 16th. By the time, on the day, this court will finally dispose of the matter.
16th, yes.
Whatever are the concerns pertaining to the visitation, pertaining to the maintenance, all the documents shall be on record, all the material shall be on record, and finally, the matter will be heard on the day to it.
Regarding maintenance.
Maintenance on
And of course. Lord, prompt payment of the maintenance, what he's giving,
Then
the rents and other things are also not being paid.
As per the earlier order passed by this court, the father shall ensure that the payments are made
Promptly, that's all.
promptly. Yes.
Cell number 25.
Millards. And for the petitioner appearing through V similar.
Yes.
Millards appearing through V similar.
Yes, Mr. 20?
25.
Where is Mr. Dhawan? 25 in first list or second?
First list 25th. ma'am.
First list.
25, yes.
No, this is an application.
You appear for the respondent.
I'm for the respondent. madam. Before the trial court, I'm the petitioner.
He is for the petitioner.
He's the respondent. Before the trial court is for.
No. Before this court, he is for the petitioner.
He's the
Yes.
I'm
petitioner.
Yes.
Last,
Yes.
last occasion, Millards has directed to the trial court to submit the pendency report, Millards.
Yes. Where is the report? Yes, he is seeking a mandamus.
No?
He's seeking a mandamus.
Yes, madam. Sure. sir.
Where is the report?
Rule 17 application was dismissed by the trial court. So it's challenging that order.
Recalling in reopen, Millards, in respect to cross-examination, further cross-examination of the petitioner.
Lords, this is the third time they have come up with this application. The
1 minute, let me just look at. Office note shall be there, no? Bengaluru, what did they say? Appearances, order date has been communicated. Report awaited. Called. List this matter on Tuesday and send it to the chamber. Ask the registered judicial to come. Let me understand what's it.
Plus interim order may kindly be acted.
Interim order earlier granted is extended. Yes, next.
List number 2, serial number 13. List number 2, serial number 13.
Time for the respondent. Respondent number 1, my lord.
List number 2, serial number
13.
MFA.
In the morning session also, they have asked time.
You appear for the respondent.
Respondent number 1.
Where is Pradeep? Shivanagoda was here.
Usually you will be there.
No, he was here just now.
His colleague has come in the morning session, he was there.
No, now also Mr. Shivanagoda. Yes, Mr.
Sonne
Shivanagoda.
is there.
13. You are saying morning also you are not there.
No, I was.
No. His colleague was there.
Order is in Kannada.
Yes, my lord.
I will translate.
And all
Only
depositions in
point
Kannada.
for consideration in this case, my lord,
You are on what ground?
we are on the liability on the ground that the chassis driver was not having any driving license to drive the vehicle. Chassis was filed under section 3
With regard to
181.
pay and recover.
That's all.
The only ground.
That is the only ground.
How do you say you are for the
I am for the claimant. my lord.
No, nothing.
He is appearing for the claimant.
So just tell the offences are under
Section 3,
section
3 read with 181
and
And 3-1 of
with
the
181 of the note.
other section.
Please.
No. IPC section.
IPC.
Where do you get that? Because that's in
It
Kannada
is
I'm
in
asking.
chassis.
279, 304A was there.
79.
304A.
180 and 181
one
of the motor vehicle act.
in the charge sheet they have added.
279, 304A.
Please.
And
180 and 181
180, 181 read with
of the motor vehicle act.
180, 181 and section 3
No, 180 and 181.
of the Motor Vehicle Act.
Please.
Opposite vehicle is?
The tractor, the vehicle is.
It's a case of death.
Oh,
yes.
It's a case of.
Agreed with her. Award passed in MVC number 873 of 2016 dated 29 July 2019. The insurance company is before this court. The only ground on which the insurance, what was the reason given by the tribunal why it pay and recover was not ordered?
They have not ordered the pay and recovery on the ground that para 16 it is there. What the court has come to conclusion that as per the chassis, one BRS was the driver. Subsequently, the owner of the vehicle is the father of the driver. Given the statement stating that my son was also called as a Santosh Kumar. Santosh Kumar is having a driving license. Basing on that, court has not considered that our opinion.
But ultimately, charge sheet is filed against.
Biresh was the driver. What he says that Santosh is my son. He is also called in my village.
So where will the charge sheet and the contents will go?
That they have not challenged. He has admitted also. He has not challenged that charge sheet.
Agreed by so also the insurance companies before this court. The vehicle that is involved in this case is a tractor.
Tractor.
The in the accident, because of the rash and negligent driving of the driver of the opposite vehicle, that's a factor. The deceased lost his life in the said accident. The court had granted compensation of an amount of rupees
5 lakh.
5 lakhs.
5 lakh rupees and held that the insurance company is liable to pay the compensation. It is a contention of the land counsel for the insurance company is the crime is registered under section 279 304A, read with section 180 and 181 of the Motor Vehicles Act, which clearly shows that the driver of the offending vehicle is not having a valid driving license to drive the vehicle. When the driver is not having the driving license, the insurance company, there is the principle of pay and recover applies. The insurance company will pay and will recover the same from the owner of the vehicle. Next part. The land counsel appearing for the respondent claimant submits that the insurance company, whether the insurance company is liable to pay the compensation. The court had rightly dealt with the issue and considering the evidence of the owner that the one the driver of the opposite vehicle is also known as Santosh.
Santosh. Yes,
It's also known as Santosh, and that Santosh
alias
is-
Biresh.
Alias Biresh,
Yes.
and Santosh is having a driving license.
And my lord, they have father and son, they have come before the honorable tribunal and they have given the evidence also saying that my name used to call as Santosh Kumar as well as
Did he place
Biresh.
before the court the driving license?
No, my lord, even there was a suggestion from them that has been denied by the,
No, it is mere coming before the court is not sufficient.
yes, ma'am.
You have to give the, you have to.
No, that
place
they have
the-
not produced any document. Even either the father or the son.
It is submitted that, and the court had rightly held that the insurance company is liable to pay the compensation expired, having heard the counsels on either side, there is a material non-record. When the owner and his son were before the court, it is a responsibility of the owner to place before the court the driving license. Mere stating that he is having a driving license, Biresh is known also as Santosh, are not the reasons for the court to say that there is driving license. Considering the charge sheet that is filed under section 180 and 181 of the Motor Vehicle Act for violation of the terms and conditions of the license in the considered opinion of the court, the principle of pay and recover will apply in the light of the law later on insurance case. Accordingly, the appeal of the insurance company is partly allowed by applying the principle of pay and recover. The insurance company shall pay and recover the same from the owner of the vehicle. The amount in deposit shall be forthwith transferred to the trial court.
Cell number
Great.
26. Prasanna Shetty.
20? Yes.
Same distance.
Who appears?
K. Prasanna Shetty for appellant, Ashok N. Patil for respondent.
Where are they? Both of them? In other court. These matters Tuesday, both of them. Yes.
List number 3, serial number 4, Manmohan PN.
What pass over? How many times I'll pass over? There are no other matters for me. There are no matters. What to do?
My lordship.
Better argue.
No.
Yes.
I'm filing an application, my lordship. Before my lord ladyship takes up the matter regarding the affidavit or the contentions taken by the opponent, I just want to bring to the record of this court. A copy has been served to the opponent. Oh, sorry, madam, idu copy. That is the madam, idu copy. Sorry.
Office copy.
It has been served. My ladyship, when this writ petition was filed, the appellant had sought for a stay from this honorable court, and on 13 December 2023, this honorable court was pleased to grant an order which clearly said
That's why interim order is vacated.
It is not vacated.
It's vacated.
It is existing. The order is existing. They have not complied with the order till date, my lordship. The order has not been complied, and that's the reason why I have
Against the
been.
interim order, they were, no, we don't go into all that.
No,
now.
my
Let's-
lord, my
let's-
lordship, my application is specifically that this application might be dismissed because the appellant has approached this court and not complied with the order of the court. My ladyship has been telling since morning, asking the advocates to make the payments as per the order of the court. Any interim order of the court has to be complied by the parties. It may be me, it may be him. An order specifically asking him to pay the arrears 50%. He has not complied with. And there is a specific direction again on 13 January 2025, which has not been complied till date, my lordship.
No, please come, don't come with another ground. And there
It's
is no,
not a ground.
There is no end to this. I'm hearing it finally. I'll hear it. That ground will also be considered. So
At least
please
it may be
argue on the
taken on
merits of the-
record, my grievance,
Yes,
because my lordship.
I'll be recorded. It will be recorded. I will, at any cost, I will dispose of this petition. No other grounds. We'll hear it on the finally on the merits of the matter.
Okay,
Nothing
my
else.
lordship, I have no problem with that, except the fact that it should be taken on record, that even after an order exists, directions have been given, the appellant has wantingly not complied with any orders of the court.
Yes.
So that is my contention, that I am requesting the court to please pass an order on that application. On the last occasion, on 11th of June, my lordship, my ladyship.
Yes.
My ladyship, I'm filing my objections to the affidavit filed by the respondent, with specific
You should have filed
documentation.
it in the registry. Why are you giving it in the
My
court?
ladyship, I'm coming all the way from Bombay and Bangalore. I am not in Bangalore. The reason I traveled today and I have been here, I'm not been able to file a copy.
Not the problem of the court. That's not the problem. There is a procedure. Everything court can't take it. No, there is no, because all the documents are given like that, there won't be it won't be in line. I have to search for every document. Where is it? How is it?
No,
Take
my-
it.
Thank you. The appellant has filed his affidavit.
Where is the impugned order? Please come to the impugned order. Page number. Where is the main writ petition?
Give the files. My ladyship, I will also like to bring to the court's notice that an affidavit for assets and liabilities has already been filed before the trial court on 6th of February 2023, where all the documents concerning regarding the assets and the liabilities of both the parties have been filed along with the affidavit.
Will all these be stick at the back side or in the front side?
Seniors.
He's there, he's working.
So my only humble request is that that affidavit also should be taken into consideration, because all my documents I have submitted then and not submitted now, because it is just a repetition of the facts that were there. Like, Sujan? Come on. Should I serve it to them? Sign it.
CRPC. 125 CRPC.
Thank you. Assets and liabilities are daily.
These copies are filed just filed. I have to file these copies.
Yes. Yes. Hmm. Yes.
Lord.
Yes.
Can I request the court to turn to page 34?
Yes.
To para 21.
Yes. I have read till 25.
Grateful.
Anything in between you want to emphasize on a particular paragraph, you can mention that.
Please, Lord. No, I think from para page 24, Lord, I'll just take notes of para 10 for a moment. My apologies, Lord, I got held up. I'm a little late.
Yes.
Page 24, para 10. Please see the last 4 sentences in that paragraph.
75 different cases.
Yes, 75 different cases are filed. Then, can I request the court to please turn to page 34 itself.
Yes.
Para 21, the court has already read. I will not trouble reading it. Lord said, ask me to read from para 20. Can I request the court to please turn to para 22 at page 38?
Hmm.
The petitioner in her petition as well as in her examination in chief has specifically stated that though she is a well qualified physiotherapist, but because of the future of her son, And for the purpose of family welfare, she has given up her profession and started giving 100% to her son, her family, and now she is unable to maintain herself. In view of the decision in Rajati was so and so, the onus shifts upon the respondent to establish that the petitioner is financially sound enough to maintain herself and he has not neglected her. But the respondent except contained in the plain petitioner is very rich lady possessing gold and diamond jewelries.
No evidence is adduced, is the
No
finding.
evidence is reduced.
Yes.
Then please turn to para.
23 also, it is
Yes.
discussed.
Can I request the court to please turn para 23? It's the same thing.
Same thing.
The court comes to a conclusion. Even during the crossing of PW1, I do not find any substantial material. Middle portion, petitioner is unable to maintain herself. Here again, at the cost of repetition, I would like to reiterate, unable to maintain herself by the petitioner means she is not having sufficient income to lead her life in the way she was leading before, so and so. Then para 25.
It's her contention about your income.
Yes, she says
Para
40 lakhs,
26,
etc. Then
court records about the losses till 1996. to
yes.
19.
Now, can I just pause here for a moment? Can I request the court to please turn to her affidavit that is filed before the family court?
Where is it?
Madam,
Dated, sir.
affidavit, chief affidavit. I think it is page 175, the LCR. Page 175. But in the meanwhile, can I continue? Then I'll take my lots to that, so that it will save the time. I was taking the code through para 26 with regard to page 41. On perusal of exhibit P10, it appears from 1996 to 1998, business the respondent was running under loss. It is not in dispute that since 2011, the petitioner is not residing
170.
at page affidavit is at page
170. It's
175. Yes.
Examination sheet.
Yes. Of the respondent.
Hmm.
Can I request the court to please turn to para 3.
Yes.
Here she says that they initially rented the flat, etc. Then her parents helped that is the petitioner, to purchase the factory site and residential house. It's in the middle of that paragraph. My lord should get it. As Shailesh was running a factory and appraised my parents that he should buy a site so that the factory and residential house together can be constructed for the purpose of running business and stay. Out of 50 cents of the land purchased, 20 was registered in my name and 30 was registered in the respondent's name. Then please turn to para 4. I am a physiotherapist, and prior to marriage, I was working in various hospitals in Mangalore, and even I used to go to home visits to the patients. As the financial condition of the Shailesh was not good, I used to go to work. I first conceived during April 1999. Then can I request the court to please then turn to para 7.
Yes.
Middle of para 7. It starts with during 2009. I was working in US and availed loan of $50,000 and gave it to respondent. After the birth of my child, because of extramarital relationship with other ladies, we used to fight. Then please then turn to para 8.
Yes.
Always he was insisting my parents to give him money in cash on the ground that he has lots of criminal cases, criminal labor filed against him, and there is a rescission. He could not pay the salary of his employees and to meet the legal expenses of lawyers, bail, and always used to pressurize my parents to extract money by cash while pressurizing uh, property in Deralakatte. Money was paid by my father in cash. Criminal cases started from 2007. Prior to that, also he had extracted money from my parents for the purpose of purchasing raw materials for import and export. Then please turn to the next page, page 6 of the chief. This is very important. Can I request the court to please turn to about fourth sentence after fourth sentence. It says Mr. and Mrs. Bruzo had filed criminal cases against him in Mangalore court and company petition filed before the board at Chennai. He told me that he suffered loss in his business and because of his criminal and other cases, he forced me to take up a job at the US. Later on, he told me that as I was one of the directors of the company and my name was also mentioned as accused, I took up a job in USA in Citibank and have operating my bank card. My husband used to withdraw money from India. Then can I request the court please turn to the next page, page 178, the fourth sentence. Came down to India to attend funeral. I came to know from the staff that my husband had failed to take responsibility of the child properly. He was not looking after the affairs of the company and the salary of the employees was not paid for 3 months. As my son was alone, he to be there in the house and he was forced to run the house to company workshop manager during nights. As he was scared, I decided not to again visit USA for job. Thereafter, my husband forced me to take a job in the factory only. He officially showed me as a managing director of the company during March 2011. Since May 2009 till September 2011, I was working in this company. As he was facing many cases, criminal, labor, and company matter, and before the High Court, he had to pay heavy amount as compensation as well as fees. He has forced my parents to invest money in his company. Once I joined the company, I streamlined the affairs of the company and made sure that the payment of electricity bills and payments of staffs were made. Workers were happy and ready to work. Slowly, the company developed making profits. Lord, this is in 2011.
Yes.
So even according to her, the company was not making profit because her contention before the court is to the contrary. During February 2010, he has given authorization to Axis Bank, authorizing me to deal with the bank in his behalf. That particular authorization was cancelled during October 2011. Then please then permit me to take the court to the cross-examination, which is a portion of it is in Kannada. If the court permits, I will just translate. Because at page 32 of that cross-examination, she says that she needs about 2,000 rupees per day to meet her expenses. The second sentence, ಪ್ರತಿ ದಿನದ 2 ಊಟ ಉಪಹಾರ ಮತ್ತು ತಿಂಡಿಯ ಬಗ್ಗೆ, that is for food. She says she needs 2,000 rupees. Now, can I request the court to then turn to the order of the family court? We'll take the court back to that relevant paragraph. We are at page 41, para 27. Here again, she says that she has not been able to occupy the premises. I'll skip this portion because there is another suit also that is filed with regard to the property. Then please turn to para 30.
Yes.
The petitioner has produced Exhibit P22 to show that she was working as managing director, and on 30/9/2011, she was terminated from the said post. Exhibit P69 is a certified copy of her visiting card, which shows that she was MD of Shagal Precision India. And Exhibit P22, the copy of the Provident Fund scheme, shows that on 30/9/2011, she was terminated. It means that before converting the Shagal Precision India, a proprietorship into a private limited company, respondent terminated her from the said post. The respondent though had admitted that he was a proprietor of the said Shagil Precision India, but he tried to make out a case. But I'm only requesting the court to also note the tenor of the entire order, because it is apparent that the court has gone on to say everything against me having come to a foregone conclusion. But he tried to make out a case that he was constrained to convert the said proprietorship into a private limited company in which he started working as CEO, and later on the said company was purchased by a Swiss company, and therefore he is now working as an employee of the said company getting 52,000 as a salary per month. He tried to project a case that presently his monthly income is not more than 52,000 to 55,000, and he is having loan liability and therefore is not in a position to provide the maintenance as sought by the plaintiff petitioner. Here it is necessary to note that he converted his business into a private limited company and sold it to Swiss company only after the dispute arose between himself and his wife. In cross-examination, his deposes under Shagil Precision India was originally proprietorship concern, later turned into a private limited company. Again, it was sold to Swiss company. I do not remember on what date my company was converted limited liability company. I admit that it was converted into private limited company after dispute arose between myself and Nisha. Here it is necessary to consider the documents produced by the respondent. Exhibit R1 is styled as a memorandum of understanding between the respondent and Shagil so and so in connection with the purchase of Audi Q3 T20 TDI car. As per the contents of the said document, the company was intending to purchase the said car, but the bank had refused to sanction loan in the name of the company. And as the bank agreed to grant loan of 30 lakhs in the name of the respondent, therefore the said company entered into the said memorandum understanding in which it authorized the respondent herein to raise the loan of rupees 30 lakhs in his individual name, purchase the said car, hand over the said car for use of the company, and in turn the company shall repay back the bank loan installments. This memorandum of understanding was entered into on 4/12/2013. It is subsequent to filing of this petition. No doubt the said memorandum of understanding may be within the
What is
framework.
the evidence for the court to grant 1,80,000?
I'm sorry, Milord.
What is the evidence that is available to the court to grant 1,80,000 as
But
my
absolutely no evidence. In fact, Milord, if the court permits me to just show Milord one or two paragraphs, it is a conclusion that the cost not only should be paid towards her maintenance, but also for holiday and travel. That is the reasoning given.
What is the scope of a petition seeking maintenance under 125 and section 24?
Lords are well aware, Lord Rajneesh case, Lord, I have also placed it on record. The scope is not to show what is the amount of money. In fact, my lords had ordered that both of us file an affidavit. There is a detailed order that the Honorable Court had passed. Can I request the court please turn to that order 11/6/2025, where the Honorable Court directed that both of us should file an affidavit. Because what happened was the document relating to the transfer of the company was not on record. And therefore, my lords had directed that I place it on record, and I have placed it on record. In fact, the court draws adverse inference against me on the ground that certain documents are not produced. In fact, there was an application filed by the respondent for summoning of the documents. That application is rejected. The court says it is not relevant. But then again, adverse inference is drawn against me. The writ petition is filed. That writ petition also is dismissed. But the order is passed on the basis of adverse inference against me, saying that certain documents are not produced. Can I request the court to please see those orders as well? Because it makes a lot of importance, because one hand the court says, because she filed an application summoning various documents, the court said these documents are not required and rejected the application.
What is the, as per the order passed by this court, what is that you have filed?
But as per the order of the Honorable Court, Lord,
Your documents stated?
yes, Lord. I filed it on 1st of July 2025.
That's there.
And she has now filed the objection. She has just given me a copy. I have also filed an objections to her affidavit this morning.
Yes. What is the latest financial position?
Sorry, I'm told it's not filed. File ಮಾಡಬೇಕಿತ್ತಲ್ಲ. Affidavit ಇದೆ, ಕೊಡಿ, counter affidavit.
As per your latest bank account
Please.
of the company and of yours, what is the amount?
Sorry, Milord.
What is the amount lying in the bank account?
Please. Bank account, not. Bank account statement ಇದೆ latest.
We'll do one thing, both of you file your written arguments. It won't go like this.
No, Milord, I'll show this.
No. Basing on, whatever you want to submit, both of you file your written arguments. I will look at the written arguments and I'll pass orders.
But with regard, Milord, can I make one request?
Can't, this
No,
is
Milord, I'll
something-
just point out that account straight away. Lord, can I just request account, please turn to page 416.
No, file your, because all the voluminous documents you have filed, whatever you are referring to, refer to it, whatever submissions.
Lord,
you are
I
making.
will not take Lord more than 15 minutes. I'll just point out a few things and I'll leave it
No,
at.
for her also, it's difficult for the court.
Lord, page.
The parties
My
shall
ladyship,
file their respective written arguments, and basing on that, the court will pass orders.
Lord, may kindly Lord hear me for a minute. Lord, the reason is this.
What you can tell the court, you can always file it by a written
True,
argument.
Lords, but not for my satisfaction, at least to point out certain things. Lord, I will not take the court through everything because documents are voluminous.
Difficult for the court to look at that document, this document, something somewhere.
But all these, Lord, I will not take the court through other
There will be
documents.
at least a compilation for all this.
But no, I'll
by
do that, Lord.
Party.
But I will do that. No difficulty with that. I'm only, Lord's asked me a pertinent question as to what is the document with
No,
regard
I'm
to
not
bank.
saying about the time taken with all these documents. It's difficult for the court, and it is not this case is not worth spending that much of time. It's a very simple issue.
True.
You please make out your place your written submissions. I will record because hours together we can't spend.
No, I'll not take more than 15 minutes and I'll leave it at.
And again, she has to argue.
Only even Lords may give her not same amount of time.
my ladyship, on the last
Because
occasion,
what
my
Lord is
ladyship-
being done is, Lord,
One second, if I can just make a submission. On the last occasion, my ladyship had asked us to file an affidavit specifically asking for the sale transaction that happened in 2013, which they say they have sold the company, which they have produced documents which are not the registered sale documents. They have just fabricated some documents which I can
This is how
convince
it's
the
going
court.
to. This is how the whole issue is going to be.
I can convince the
So
court
I
in
have-
5 minutes.
I can't spend that much time. Both the parties are
My
directed
lord-
to
my
file their
ladyship, I'm
written
just-
documents, written arguments. Basing on that, the orders will be passed.
My ladyship,
Lord-
Let her go.
can I?
It is- keep it. Yes.
I'll just make one submission. Now, Lords, insofar as the reasoning that is given by the family court, it's primarily on the ground that adverse inference is drawn against me. Lord, this Honorable Court and the Honorable Supreme Court have time and again held to draw adverse inference. What are the requirements to be done? Here, in fact, the trial court, there is no notice issued to me, produce a document. There is an application filed, in fact. That application is rejected by the family court. Thereafter, the family court says, because you have not produced this document, I'm drawing an adverse inference against you. From our own pleading, in fact, in OS number 1 of 2012, but I'll place it along with them.
Placing, what you can do is, you file your written arguments. All these documents which you are relying on, you say a particular paragraph and so and so. File that.
Very well.
To it. It will be easy because it won't stop anywhere.
But what has happened is there are multiple documents that are filed. But can I make one request in the alternative? Now, what has happened is she has filed an affidavit which I have emphatically denied. What has happened? She says in her affidavit that she is spending about 5 to 6 lakhs per month, and that is the affidavit that she has filed now before the court. And she has been telling my lords that she has no source of money to sustain herself. I pointed out to the court that she has income. She has sufficient amount of money, but all that has been suppressed in her affidavit. If she is able to spend 5 to 6 lakhs per month, then it is very clear that she has enough and more money. But those facts have not come up in her affidavit. Therefore, my submission is the order of the family court has completely gone on the basis that I was making profits or my name was there in an article. That article was published earlier when the company was doing business and doing good business. And that article cannot be a basis for the court to come to a conclusion with regard to my.
Both the parties should file their.
My ladyship, I just want to make one submission. The learned counsel has been telling the court that there was an order rejecting my application. If the counter that I have filed at the moment,
Whatever.
there is an order from.
Whatever his submissions are, I will not take it on the face value of it, isn't it?
Agree, my lord.
That's why.
I just want to point it out to the court that there is a specific order for him to produce documents in 2012, my ladyship. It is not today, and they have not produced it till now.
That's why what all both of you want to say, you say you by way of written arguments, you see you submit that so that 2011 litigation that is pending will put an end to that.
Agreed.
And with this, one document from his side, one document from your side, and court has no patience to look at all that.
Agreed. My ladyship, on that particular order.
Can I file this counter to her affidavit notes? I have served a copy on her.
That's what I'm not even able to understand who filed what. There are about these many, everything filed in the court. She says she has difficulty because she is party in person. Some of the documents you also filed in the court without filing it in the registry.
But I'll file it in the registry.
And ask the registry to, in a chronological order, ask them to keep all the documents.
My ladyship, a humble submission.
Yes.
A humble submission, my ladyship.
Huh?
I am filing 2 applications.
Your applications that are filed have to be numbered.
I agree, my ladyship.
Give it to her. Give it to her. All of that has to be numbered. After unless and until they are numbered, I can't give any direction. I can't consider it as an application.
My ladyship, just before the honorable court takes up to pass an order, I am filing this application for the fact being the appellant who has filed his affidavit has wantonly underplayed his rental income that he's earning from the property. And that's why I'm asking for a survey, independent survey. Both the parties can be directed to get a surveyor.
What do you think? What is the scope of the writ petition? What the High Court is doing?
It's an RPFC, my lordship. My whole maintenance for the rest of my life depends on this. He has wantonly short 50,000. I will convince.
In fact, this exercise is not required to be done in RPFC.
Agreed.
Basing on the order, if I have to pass, it is altogether the conclusion will be different.
Agree, my lordship, because an adverse inference is taken was 2012.
And now all this exercise, you can't expect this court to do in RPFC.
But in 2012, an adverse inference is only taken because since 2012, he has refused to bring documents. Now they come before this court wanting to submit.
Please file your written arguments, give it to her. She will file her IA. Whatever letter IAs be numbered, come up with your written arguments. I cannot hear this matter in this manner. When can you file your written arguments? On that day, in the court itself, I'll pass order. I'll look at, and I know arguments. No arguments from either of you. I will look at your written arguments. I'll understand. If I have any doubt, I'll ask. I'll pass orders. I don't want any arguments. Everything needs to be part of it. That written arguments needs to be numbered, not giving in the court. You file by way of a memo. Give her, she will give you. They should be numbered. Basing on that, I'll pass orders in the court. When do you want?
On the 12th. Not 12th of September, March.
Can you do it by 12th September?
No, I have matters where I'm appearing party in person.
Yes. 23rd September. This is the matter on 23rd September.
Good.
By the time both the parties shall file their respective written arguments in the registry, and whatever the documents that they are relying upon, in which on what date they are filed before the court, what is the page number and all shall be mentioned in the written arguments. On the next date of hearing, looking at the written arguments, court will pass orders on the same day.
But can I seek one indulgence, ma'am? Before the trial court execution is filed, the second execution also is filed, is what I'm told. I'm not in a position to pay the kind of money that is ordered by the family court.
My lordship, he's not
But
paying
at least not till
anything.
the matter is decided.
Even he's not paying any maintenance. 12,000, how am I supposed to survive? 2,80,000
But my
has
income
been
is
ordered.
about 40 odd
In
thousand.
front of Supreme Court, 1 lakh they were paying. That time they
Yes,
didn't have
any
any
other
problems.
Any other signatures?
Great.
Much obliged.
What did she say?
She is saying both of you file written arguments. I will look into it. If I have a doubt, I'll ask you. I'll pass orders on that.
ಅದು ಎಷ್ಟು ಗಂಟೆಗೆ ಫೈಲಿಂಗ್
She's going to pass an, she's
4
going to pass
o'clock
an order on
that
merits.
ಫೈಲಿಂಗ್ ಕೌಂಟರ್
She's going to hear,
ಕ್ಲೋಸ್
see written
ವಾಪಸ್
submission, then
ಹೋಗ್ಬೇಕಂದ್ರೆ
pass
ಫೈಲ್
orders.
ಮಾಡಬೇಕು ಮೇಡಮ್ 4
Then-
ಗಂಟೆಗೆ ಫೈಲಿಂಗ್ ಕೌಂಟರ್ ಕ್ಲೋಸ್ ಆಗುತ್ತೆ ಇಫ್ ಯು ವಾಂಟ್ ಟು ಫೈಲ್ ಇಟ್ ಅಂತ ಫೈಲ್ ಮಾಡ್ಬಿಡಿ ಹೋಗಿ ಬೇಗ
Counter. No, wait 1 second. Okay, then I am not going to file number and applications. I will take the copy back. Yeah. I'll just rush to the thing because the counter affidavit, counter to that, that I will file it now because before it becomes 4 again they will. But remaining 3 applications, I will take it back. What you were asking?
You said 2012.
I need to ask in specific cases, specific. Ishtaranindra. ಅದು no. It's there. It is the order. Counter. Counter affidavit. Application. That order is there. One need of the doors was not. The doors was the petition. And the right. Not in this. After something will be in it said that following from cut ಮಾಡಬೇಕಾಯ್ತು ನಾವು please sir.
Please have a cut cut.
It is my case.
ಏನೋ ಒಂದು ಟಿಕ
You ask him to pay some 12,000. Any made in my house. She had a house. Who was earning my salary? I know you had a
Class is a Manmohan PN. You respond and
because anybody else wants it.
the mail I sent it to madam. But of the petition copy, which is the petition copy? ಇದು ಏನು
No. I won't get it out. You better get it.
ಅದು chronological ಆಗಿ ತೋರಿಸ್ತಾರೆ ಏನದು ಎಲ್ಲ ಇದೊಂದಾ ಇದ್ರ ಜೊತೆ ಇನ್ನೊಂದಿತ್ತಲ್ಲ ಇದೇನಾ ಇದೆರಡು
ಅದನ್ನ ಆರ್ಡರ್ ಶೀಟ್ ಮಾತ್ರ ಕೊಡಿ.
ಹೆಂಗ್ ಇಡ್ತೀಯ
ಏನಾಗಿದೆ ಇದು?
ಅದು ಬೇಕು ರಿಟರ್ನ್ ಆಗಿ LCR ಅದನ್ನೆಲ್ಲ ಒಟ್ಟಿಗೆ ಕಟ್ಬಿಟ್ಟು ಇಟ್ಬಿಡಿ.
ಇದು ಅದು ಎಲ್ಲ ಒಂದು ಸ್ಟೆಪ್.
ಅಂದ್ರು ಅದೊಂಚೂರು ಕಟ್ಬಿಟ್ಟು ಬಿಸಿ ಯಾರು ಕಟ್ಟಾಗ್ತಿದೆ.
ಆಯ್ತು ರೆಡಿ ಮಾಡಿ.
ಸಣ್ಣ ಅದೇನಿಲ್ಲ ಇಷ್ಟು
ಅದು
ದಾರ
ಬರಲ್ಲ.
ತಗೊಂಡು ಒಲ್ಯದಲ್ಲ
ಹೆಂಗಿದೆ
ಒಲ್ಯದಲ್ಲ ಹಿಂಗೆ ಇದೆಯಲ್ಲ ಬಂಡು ಅದನ್ನ ದಾರ ಟ್ಯಾಗು ಏ ಹೌದಮ್ಮ ಇರೋ
ಒಂದು ಬಡ್ಲಿ ಇದೆಯಲ್ಲ
ಅದು
ಟ್ಯಾಗ್ಗಳು
File. This was a lot.
ಇಷ್ಟು ಚೇಂಬರ್
ಅಷ್ಟು ಕೇಳ್ಬರ್ತೀಯ? ಆ ಕಡೆ ಇಟ್ಕೊಂಡ್ರೆ ಆಯ್ತು.
ಇದಿಷ್ಟೇ ಅಲ್ಲ ಚೇಂಬರ್ಗೆ
ಅಷ್ಟೇ ಅಮ್ಮ.
ಗಾಡಿ ಏನ್ ಬೇಡ ಬಿಡಂಗ ಆ ಕಡೆ ಏನಾಯ್ತಾ ಫೈಲ್ ಅಲ್ಲಿಂದ ತರೋದು
ಅದೇನೋ ಇದ್ರದ್ದು ಆರ್ಡರ್ ಶೀಟ್ ಮಾತ್ರ ಇದೆ, ಫೈಲ್ ಬೇಕಂದ್ರೆ ತರ್ತೀನಿ ಅಂತ ಅಂದ್ರು ಅಷ್ಟೇ. ಅವರು ಒಳ್ಳೆ ಕೇಳು ಬೇಕು ಅಂತ ಅಂದ್ಬಿಟ್ಟು.
ಇದು ಆ ಕಡೆ ಫೈಲ್ ಕೂಡ ತರೋದು ಇಲ್ಲಲ್ವಾ ಕೊಡ್ತೀನಿ